Criminal petition. Good. Yeshne isvidu? 24. ಆಯ್ತು ಯಾವತ್ತೋ ಡೇಟ್ ತಗೊಳ್ಳಿ. Good. 2023 ಇಂದ ನಮ್ಮ ರೋಸ್ಟರ್ ಶುರು ಆಗುತ್ತೆ. So yes. Which year? 21. Oh. Which year? 25. You want final disposal? Application for? You're for the appellant? ತಗೊಳ್ಳಿದ್ದೇನು ಆರ್ಡರ್ಸ್ ಆನ್ ಐ ಅಂತ ನಾಳೆಗೆ ಹಾಕಿ ತಗೊಳ್ಳಿ 22. PC Act, huh? PC Act, I think they should suffer. Salpa, there should be some sufferance at the hands of law. This is what you say. Correct.
Adjournments page wise. Adjournments page wise, list number 1. Page number 8, serial number 30 to 32. Page number 9, serial number 33 to 37.
ಯಾವುದು?
37.
37. One counsel for the appellant seeks time list on date.
24th April. Page number 10, serial number 38 to 43.
41. Learn counsel for the appellant seeks time list on also. ಇದೆಲ್ಲ ಅಡ್ಮಿಷನ್ಗೆಲ್ಲ ಯಾಕೆ ಟೈಮ್ ತಗೋತೀರಪ್ಪ? Really do not know. Learn counsel for the appellant seeks time, but this is for admission. List on also, yes.
Page number 11.
Interim order granted extent to the next date.
Page number 11, serial number 44 to 49.
40?
For the appellant, my lords, counsel on record is unwell, my lords. Kindly short accommodation.
The suit is for possession.
Please, my
So
lords.
it will be
Already
admitted.
interim order has been granted, my lords, in
That
this
is
matter.
right. We'll consider it. If it can be admitted, it will be admitted.
Short accommodation, my lords.
I can't dismiss it, madam.
Please, my lords.
Yes, let us see.
My lords, next week, my lords, counsel on record is unwell, my lords.
Madam, I will see the appeal. If it merits admission, I'll admit it. If it doesn't merit admission, I'll adjourn it.
Please, my lords.
Page number 12, serial number 50 to 53. Page number 13, serial number 54 to 56. Page number 14, serial number 57 to 59. Page number 15, serial number 60 and 61. Page number 16, serial number 62. Page number 17, serial number 63 to 65. Page
my lord, serial number 64, my lord. I am for the appellant, lord.
Serial number?
64, serial number 64, lord. For final hearing.
64.
Please, lord. Week's time may be granted, lord. So today, senior not there. Week's time, lord.
Please intimate the other side. Learn counsel for the appellant seeks time. List on so and so. Yes. You should be happy 2025 matters are being taken up for final hearing and lawyers are not ready.
Because the senior is admitted in hospital for eye operation. That's why, lord.
ಏನೋ ಒಂದು ಹೇಳ್ತೀರಪ್ಪ.
ಇಲ್ಲ.
2025 it is appearing for final hearing.
Please.
Yes, correct.
list number 1 for orders matters, serial number 1, Lakshmi Holla. Serial number 41, interim order extension.
41 ಅಲ್ಲಿ ನೋಡಿ interim order extension.
I'm filing my objections to the.
ಕೊಡಿ ತಗೊಳ್ಳಿ. Yes. Yes.
Please see the very first paragraph of the Commissioner's report.
Hmm. Yes, please.
It is submitted that this honorable court so and so was pleased to appoint so and so to verify the boundaries of site number 78. Please note, to verify the boundaries of site number 78.
Now, where is the order? When was the commissioner appointed?
31-1. May I just pass on the order?
31/1/2026.
Yes.
What the
INMR is filed by the appellant for appointment of a court commissioner to visit the spot and give a report about the boundaries of site number 78 claimed by the appellant and site number 71 claimed by the respondent, and whether site number 77 lies adjacent to the properties claimed by the appellant and the respondent. In the affidavit accompanying the application, it is stated that the dispute intersect between the appellant and the respondent is about location of the suit property, in as much as both the parties claim that site number 77 is abutting their site, though they are not neighbors. It is claimed that an application must have been filed before the civil court, which was not done. It is therefore prayed that a commissioner be appointed to visit the spot and give a report regarding the boundaries of site number 78 and site number 71, and also a report whether 77 abuts the site claimed by the appellant and the respondent. The learned senior counsel so and so is claiming site number 78, while the respondent is claiming site number 71. He contends that site 77 is claimed to be abutting the site of both the appellant and the respondent. He therefore contends that the only way to ascertain this is by appointing a commissioner to visit the spot and submit. However, the learned counsel for the respondent opposed the application and contended that the respondent has already constructed a building over the property which he claims to be site number 71, and therefore no useful purpose would be served in appointing a commissioner. He submits that the commissioner cannot undertake the exercise of identifying the boundaries, as it would be difficult for the commissioner to give a report as to which is site number 71 and which is site number 78 and where exactly site number 77 is located. He, however, submits that if the appellant and the respondent are claiming the same site, then it is necessary that the same is ascertained through a commissioner, so that an appeal could be taken up for disposal, as it is only a suit for injunction. In view of the aforesaid submission, as rightly contended by the land counsel for the respondent, the suit from which the appeal arises is one for injunction in respect of site number 78 claimed by the appellant. The respondent claimed that the property which is in the possession of site number is site number 71. Therefore, the only question that needs to be considered is whether both the parties are claiming the same site. If the answer to the aforesaid is in the affirmative, then a suit for perpetual injunction may not be maintainable. However, if both the parties are claiming different properties, then perhaps the suit for injunction may be maintainable in respect of property claimed by the appellant. Therefore, in order to ascertain whether the appellant and the respondent are claiming the very same site, this court appoints so and so as commissioner, who shall visit the property and submit a report whether both the appellant and respondent are claiming the same property. The office is directed so and so. The rest of the things are. No, Minad. It is made clear that neither the appellant nor the respondent shall give any instructions to the commissioner, but the commissioner shall only call upon the appellant and the respondent to identify the respective properties, and after such identification, the commissioner shall submit a report whether both the parties are claiming the same properties or different.
So therefore, whatever the commissioner said in a report may not have any significance.
Yes, ma'am, that's what.
The commissioner says that she was appointed to identify the boundaries. Court has never said. Court only said, go to the spot, see which side the appellant identifies, which side the respondent.
Then there is no purpose, because both of what has happened is like this. If the suit was filed in 2010, there was no injunction. Then he started construction. The injunction was not there. Now, my lord, he says, this is my house. I'm not disputing that he has constructed on my site. But
then you can.
his own records show, his own records, not my records, that his property is sandwiched between 78, 77 and 79. How can 71 be sandwiched between?
See, therefore, you must have filed a suit for declaration of your
That's
title.
what I said, Millard. I will be permitted to file a suit for declaration, Millard, because your last may record my request, Millard, and close.
If you are entitled to file a suit in law.
But the limitation, but section 14 ali adu.
You have to explain.
Section 14 ali explanation ಕೊಡಬೇಕಾಗುತ್ತೆ.
You give your explanation.
ಒಂದು observation ಮಾಡಿದ್ರೆ you can make it.
No, I will not make it. See, the court cannot.
No, your Rashmi,
court cannot.
The trial court has held.
Cause.
The trial court has held is two different sides. Trial court has held that. Para 19. That's the reason. Otherwise, I would not have troubled your lordship with that prayer. The trial court itself has held that. And all those documents ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲೂ ಅದೇ ಹೇಳಿದ್ದಾರೆ.
Being agreed by the aforesaid judgment and decree, the plaintiff is before this court. The learned senior counsel for the plaintiffs submitted that the defendant had categorically admitted that he has nothing to do with site number 71. And that he had no objection. 78. And that he had no objection for the suit to be decreed in respect of site number 78. He therefore contends that the trial court could not have gone further in holding that the plaintiff should have filed a suit for declaration of title. He contends that the property claimed by the defendant is site number 71 and not site number 78. So he submits that the boundaries of site number 71 can obviously cannot be bound on the western side by site number 77. And hence what is in occupation of the defendant is site number 78 and not 71. He therefore submits that the trial court must have decreed the suit for injunction and must have directed the defendant to remove the construction that he had put up for the suit property during the pendency of the suit. Full stop. He further submits that the trial court misdirected itself in suspecting the sale deed dated. Registered sale deed adu? Suspecting the sale deed dated?
1 second.
28/2/2004. On the ground that
May person the list of dates.
on the ground that
Schedule ಇದೆ Schedule ಇದೆ I can pass.
On the ground that ಸ್ವಲ್ಪ ನೋಡ್ಬಿಟ್ಟು ಇನ್ನೊಂದ್ಸತಿ ನೋಡಿ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ತೀನಿ. Just go through it and ಅಲ್ಲ ಮಿಸ್ಟೇಕ್ ಇತ್ತಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಸಸ್ಪೆಕ್ಟೆಡ್ ಯುವರ್ ಸೇಲ್ ಡೀಡ್.
On the ground that rectification deed ಅಂತ ಹೇಳ್ತಾರೆ. Rectification deed ಎಲ್ರಿಗೂ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರಿಗೂ ಮಾಡಿದ್ದಾರೆ, ನಮಗೂ ಮಾಡಿದ್ದಾರೆ. That's what I have given this. ಈ ಡೇಟ್ಸ್ ನಲ್ಲಿ ನಮಗೆ
ಮಧ್ಯಾಹ್ನಕ್ಕೆ ತಕ್ಕೊಡಿ
ಇಷ್ಟು ಕೊಟ್ಟೆ.
ಸೊ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಇಟ್ಕೊಂಡು.
Rashmi, can you have it tomorrow?
Tomorrow for dictation.
Serial number 2.
Representative, appellant lord. I filed the IA in the office. Rashmi, I have it next week, my lord. I filed the IA in the office. Rashmi, call it.
Pardon?
I filed the IA in the office.
Non-filing of better affidavit in support of IA 1 of 24, continuation of 795 days.
I have filed it in the office. Your
ಏ,
last
ಕೊಟ್ಟಿದ್ದಾರೆ, ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ, ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ. I requested him.
ಪುಟಪ್ ಆಗಿದ್ದೇನ್ರಿ ಬೆಟರ್ ಅಫಿಡವಿಟ್?
Next week ಹಾಕು.
ಅಲ್ಲ, ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಹಾಕಿಲ್ವಾ? ಆಫೀಸರ್ ಡೈರೆಕ್ಟರ್ ಪುಟಪ್ ದಿ ಅಫಿಡವಿಟ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಲರ್ನ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪೆಲೆಂಟ್ ಇನ್ ಸಪೋರ್ಟ್ ಆಫ್ IA 1 of 24. ಲಿಸ್ಟ್ ಟುಮಾರೋ. ನಾಳೆ ಹಾಕೊಳ್ಳ?
15 ಹಾಕ್ಬೋದು. 15.
ಲಿಸ್ಟ್ ಟುಮಾರೋ.
ಅಲ್ಲ, ನಾಳೆ ಬೇಡ. ಒಂದ್ ವಾರ ಟೈಮ್.
ನಾಳೆ ಬೇಡವಾ?
ಒಂದ್ ವಾರ 15th ಹಾಕೋಬೋದು. 15.
16th.
ಆಯ್ತು.
Yes, Mr. Tilak Raj.
Please, Tilak Raj, SV.
Steps in respect of deceased R1.
I appeal for the contesting respondent. That IA has been dismissed.
IA number 4,
order
IA number 4 is already dismissed as not pressed, my lords. IA number 3 is pending. Your lordships was directed me to secure DNA test, my lords. BV Nagarath, Honorable Justice BV Nagaratna's judgment, my lords. I went through that judgments. I'm seeking for DNA test. The whole case is revolves around only one crucial issue, my lords. It's the paternity of the appellants.
I'm sorry, I am suppose ಬೆನ್ನು ಕಾಲು ಹೋದ್ರೆ ಬರ್ಲಿಕ್ಕಾಗಲ್ಲ. I'm sorry, I am on online. One submission I want to make. In view of the dismissal of IA not pressed, now R1 is not represented by anybody. It has abated, and it has sued for partition. Now R1, the first son, his LRs are not there, and now the IA is not, what he wants to submit.
No, but the estate of R1 is not represented. The estate of R1 is not represented.
Yes.
But they know.
He died with, my lords, he had no issues, my lords. Since he died, we filed an application. He was a foster son, my lords. Since he was a foster son, he said, my lords, how can we bring
the respondent number 1 is a foster son.
Please, my lords, respondent number 1.
No.
We made a
Respondent
application.
number 1 is a son.
It's a son, my lords. We filed an application to bring on the foster son as in record. He objected for that.
Yes, if there is no legal representatives, the class 2 heirs are not there.
No, my lords.
Class 2 heirs.
Class 2
ಯಾಕಿಲ್ಲ? ಬಾಕಿ brothers and sisters ಇದ್ದಾರಲ್ಲ.
Take instruction from my client, my lords.
Mr. See the cost title, you will know who are the class 2 heirs. First you see who are the class 2 heirs, Mr.
Brothers and sisters are there. They are parties. There are
brothers and sisters.
ಎಲ್ಲಿದೆ ಅದು? Where can you find it?
Indian Succession. Indian Succession Act.
Indian Succession Act.
Sorry, Indian Marriage Act.
Indian Marriage Act. Please find. ಕೊಡ್ರಿ ಅದು Indian Marriage Act. ಕೊಡಿ.
It's the first heir, my lords, I know.
Sir.
The wife, mother.
You wanted to find out where is class 2 heirs. Find out. Indian Marriage Act ಕೊಡಿ. Indian Marriage Act, ಕೊಡಿ.
My lord, admittedly, they are 2 to 4 are the brothers and sisters, and 5 to 6 are the second wife.
Mr. Naran Sharma, please wait. ನೀವಂತೂ ಜೂನಿಯರ್ಸ್ ಗೆ ಟ್ರೈನ್ ಮಾಡೋದಿಲ್ಲ ಆಫೀಸಲ್ಲಿ.
ಮಾಡ್ಲಿ. I am sorry.
Juniors come like, no, they simply come. They don't make any effort.
ಆಯ್ತು, ತಮಗೆ ಬಿಟ್ಟಿದ್ದೀನಿ. I will wait.
We have to ಸ್ವಲ್ಪನಾದ್ರೂ ಇಲ್ಲಿ ಬ್ರಾಂಚಸ್ ನ ಕಟ್ ಮಾಡ್ಬೇಕಲ್ಲ, so that the tree grows straight.
I can understand.
So he says that the class 2 legal heirs are found in the Indian Marriage Act.
In the Succession Act. I plead ignorance, my lords. I'm not aware. I plead
ignorance. You can't plead. You should make efforts.
Please, my lords, in the Succession Act. Now I went through that.
Illide kodi in the succession kodi. Perhaps you have not even opened Hindu Succession Act. Not even once. Have you? Have you opened?
Please, my lords, only section 14, the women's rights in the property.
ಅಷ್ಟೇ ಒಂದೇ ಓದಿರೋದಾ? That is the only provision which you have read.
In the one also few sections, my lords.
What sections have you read?
14, 6, Indian section 6.
Indian succession or Hindu succession?
Hindu Succession Act.
So be careful when you are using words.
Hindu Succession Act.
ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಪ್ರಾಕ್ಟೀಸ್ ಎನ್ರೋಲ್ ಮಾಡಿ?
2 years, my lord.
2 years.
I was practicing in criminal side.
ಎಲ್ಲಾನ ಮಾಡಪ್ಪ. When you come and stand before the court, you should do the homework in your office or at your home.
This question, my lord,
you cannot simply come and stand.
Please, my lord, I totally understand. Sorry, sincere apologies, my lord. I'll go through this, my lords.
ಓದಿ. ಹಿಂದೂ ಸಕ್ಸೆಷನ್ ಆಕ್ಟ್ ಕೊಟ್ಟಿದಾರಲ್ವ, ಓದಿ ಕೊಡಿ ಅವ್ರು. Class 2 years ಎಲ್ಲಿ ಬರುತ್ತೆ? ಒಂದ್ಸತಿ ಆಕ್ಟ್ ತಕೊಂಡ್ರೆ, ಮಿಸ್ಟರ್, ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಿಸ್ ಗೋಲ್ಡನ್ ರೂಲ್.
Please,
I will not, I am not trying to, what you call, pull you down. When you take a bare act, please make it a point to read from the commencement of the act, how the act was enacted, for what purpose, till the last provision, repeal and savings ಅಂತ ಇರುತ್ತೆ. ಅಲ್ಲಿವರೆಗೂ ಓದಿದ್ರೆ ಮಾತ್ರ ಈ ಆಕ್ಟ್ ಏನು ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. It is like an elephant. Elephant has trunk, it has got big ears, it has got big tusks, it has got big legs, tail, big body. ಎಲಿಫೆಂಟ್ ನ ಫುಲ್ ನೋಡಿದಾಗಲೇ ಎಲಿಫೆಂಟ್ ಅಂತ ಗೊತ್ತಾಗೋದು. ಬರೀ ಬಾಲ ನೋಡಿದ್ರೆ ಎಲಿಫೆಂಟ್ ಗೊತ್ತಾಗಲ್ಲ. ಅರ್ಥ ಆಯ್ತಾ? When you look at an act, you please read from top to bottom. Only then you will understand. This is a difficulty with youngsters. ಟಕ್ ಅಂತ ತೆಗಿತೀರಾ, ಮೊಬೈಲ್ ನೋಡ್ತೀರಾ, you think that is it. You think what is mentioned there is it. That is it. ಬುಕ್ ತೆಗೆದ್ಬಿಟ್ಟು ನೋಡ್ಬೇಕು, ಆ ಪೇಷನ್ಸ್ ಇಲ್ಲ, ಆ ಪರ್ಸೀವರೆನ್ಸ್ ಇಲ್ಲ. Law is not what you think, mister.
Please.
Law is not what you think. You should read, understand. Only then you will come to know what law is. And this is what the seniors will have to teach you in the office. ನೀವು ಕಲಿಯಲ್ಲ, ನಿಮಗೆ ಬುದ್ಧಿ ಇಲ್ಲ. Unfortunately, youngsters are becoming, you're not adding value, you're not learning the way it should be learned. I'm sorry to use these hard words.
I'll take it really seriously.
All youngsters should learn the way it should be learned. ಮೊಬೈಲ್ ತೆಗೆದು ಚೆಕ್ ಅಂತ ಒಂದು ಜಜ್ಮೆಂಟ್ ಕೀವರ್ಡ್ಸ್ ಹಾಕ್ಬಿಟ್ಟು ಜಜ್ಮೆಂಟ್ ತೆಗೆದುಬಿಟ್ಟು ಇದೇ ಕಾನೂನು ಅಂತ ಅದಲ್ಲ. ದಟ್ ಈಸ್ ನಾಟ್ ದ ವೇ. ಇಫ್ ಯು ಹ್ಯಾವ್ ಕಲ್ಟಿವೇಟೆಡ್ ದಟ್ ಹ್ಯಾಬಿಟ್, ಯು ಆರ್ ಕಿಲ್ಲಿಂಗ್ ಯುವರ್ ಇನ್ಸ್ಟಿಂಕ್ಟ್, ಲರ್ನಿಂಗ್ ಇನ್ಸ್ಟಿಂಕ್ಟ್. Just because somebody has told, some judge has told something somewhere, that is not the ultimate thing. There could be a better way of looking at things. There could be a better interpretation. So therefore you should look at the law and apply your mind. There could be a second view, ilva? There could be another view. Another view you will get only when you read. Yes. Take it second class, illi the class 2.
Section 11. Distribution of property among heirs in class 2 of the scheduled property.
First class 2 ellidiyappa?
Adortini.
Madam, you please sit down. You know it? You know it? Huh? Do you know it? You do not know it. So don't lead one blind leading the other blind in dark. ಬೇರೆ ಆಕ್ಟ್ ತೆಗೆದಾಗ ಒಂದು ಕಂಟೆಂಟ್ಸ್ ಅಂತ ಇರುತ್ತೆ ಮುಂದ್ಗಡೆ.
ಇಂಡೆಕ್ಸ್.
ಆ ಕಂಟೆಂಟ್ಸ್ ನೋಡಿದ್ರೆ ಆ ಬುಕ್ಕಲ್ಲಿ ಏನೇನಿದೆ ಅಂತ ಬರೆದಿರುತ್ತೆ. ನಿಮಗೆ ನಾರಾಯಣ್ ಶರ್ಮಾ ಅವರೇ, ನೀವು ಸೀನಿಯರ್ಸ್ ಆಗಿ ಜೂನಿಯರ್ಸ್ಗೆ ಬರೀ ಅಡ್ಜಮೆಂಟ್ ತಗೊಂಬಾ, ಅದು ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡ್ಬಾ, ಇದು ಮಾಡ್ಬಾ, ಅದು ಮಾಡ್ಬಾ ಅಂತ ಮಾಡಿದ್ರೆ ಯು ಆರ್ ನಾಟ್ ಡೂಯಿಂಗ್ ದ ಹ್ಯಾಂಡ್ ಹೋಲ್ಡಿಂಗ್. ನಿಮಗೆ ಬರೀ ಕ್ಲೈಂಟ್ಸು, ಕೇಸು, ಕಾಸು ಇಷ್ಟೇ ನೋಡಿದ್ರೆ ಜೂನಿಯರ್ಸ್ನು ಟ್ರೈನ್ ಮಾಡೋ ಜವಾಬ್ದಾರಿ ನಿಮ್ದಿದೆ ಸೀನಿಯರ್ಸ್ ಆಗಿ. ಯು ಆರ್ ಸಪೋಸ್ ಟು ಟ್ರೈನ್ ದೆಮ್, ಯು ಆರ್ ಸಪೋಸ್ ಟು ಗೈಡ್ ದೆಮ್. Don't
I have
use
been
juniors only to take adjournments, only to get certified copies. Please don't do that. ನೀವು ಆದ್ಮೇಲೆ ಇನ್ನೊಬ್ಬ ಒಳ್ಳೆ there should be a good crop of good lawyers coming up. Seniors owe a responsibility, sir. Seniors owe a responsibility to the profession. You should bring up good advocates. ಸ್ವಲ್ಪ train ಮಾಡ್ಬೇಕಲ್ವಾ? Yes.
Section 8, my
I,
lord. General
I do
rules
not know.
of succession.
I think
Contents
I
ಏನಪ್ಪ ಇದೆ?
have been doing my best.
First contents ತೆಗಿ book ಅಲ್ಲಿ.
Contents, short title, application of act, definition and interpretation, overriding effect of the act, act not to apply to certain properties, devolution of interest in copersonary property, devolution of interest in the property of a Tharwad so and so, general rules of succession in the case of the males, order of succession among the heirs in the schedule.
ಏನಾಯ್ತು?
Order of the succession among the heirs in the schedule.
ಆಮೇಲೆ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಅಂತಿದೆ. Go to the schedule.
The class 2 heirs, my lord. The class 1, son, daughter, widow, mother, son of a predeceased son, daughter of a predeceased son, so and so. Class 2 heirs, father, son's daughter's son, son's daughter's daughter, brother, sister, daughter's son's son, daughter's son's daughter, daughter's son, daughter's
Now you know
daughter's
where class 2 heirs are.
schedule in the
So
schedule.
ಇದ್ರಲ್ಲಿ ಕಾಸ್ಟ್ ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಯಾರ್ಯಾರು ಏನಿದೆ ಅಂತ ಗೊತ್ತು ತಾನೆ?
Good. Please, my lord.
So you can make out who are the class 2 heirs.
Please, my lord.
Then why you say that you have to ask my client? Can't you apply some common sense?
Please, my lord. Respondent number 1 to 4 are born out of the one Pillama and Munikrishna Reddy, my lords. 1 to 4 are the 2 to 4 are the brothers and sisters.
So the class 2 heirs are there.
Please, my lords.
But why you can't say that?
Please, my lord. Sorry. Now I understand. Respondent number 2 to 4 are the brothers and sisters of respondent number 1. They are the class 2 heirs.
Then why don't you file a memo?
I'll file it, my lords.
File a memo to that effect.
Please, my lords.
ಇದು ಮರ ಹೆಂಗೆಂಗೋ ಬೆಳ್ಕೊಂಡು ಹೋಗುತ್ತೆ. ನಾರಾಯಣ್ ಶರ್ಮಾ ಅವರೇ, ಮರ ಆ ಕಡೆ ಈ ಕಡೆ ಮುಂದ್ಗಡೆ ಹಿಂದ್ಗಡೆ ಎಲ್ಲ ಬೆಳ್ಕೊಂಡು ಹೋಗುತ್ತೆ. ಅಲ್ಟಿಮೇಟ್ಲಿ ಅದು ಉಪಯೋಗಕ್ಕೆ ಬರಬೇಕು ಅಂದ್ರೆ the branches have to be pruned. If the tree has to be of some value, the branches have to be pruned. Only then the tree will be of some value. You allow the tree to grow as it wants, and you allow the junior to think however he wants. This is what happens. Please devote some time for your juniors also.
I have been trying my best, my lord. I have been trying my best. I don't know whether I
it's a request. It's not only to you. It's a request to all seniors. ಆಯ್ತು, ನಿಮ್ದೊಂದು ಜನರೇಷನ್ ಹೋದ್ಮೇಲೆ ಒಳ್ಳೆ ಜನರೇಷನ್ ಬರ್ಬೇಕಲ್ವಾ ಲಾಯರ್ಸ್?
I do agree. I endorse.
ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ?
No, I endorse your lordship's view. I have been trying my best to do that, but I am also coming to an end in my.
It's an appeal to all senior lawyers who are there in the court.
I do not know whether I
ಬರೀ
deserve this
ಕಾಪೀಸ್ ತಗೊಂಬಾ, ಅಡ್ಜಮೆಂಟ್ ತಗೊಂಬಾ, ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ಸೀನಿಯರ್ಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ಅಡ್ಜಮೆಂಟ್ ತಗೊಂಬಾ, ಇಷ್ಟೇ ಹೇಳ್ಕೊಡೋದಲ್ಲ. All seniors should do some hand holding, genuine hand holding. Yes.
Coming back to this, my lord, may I make one submission, my lord?
3 is pending.
Two is dead. She will not come as a LR now. 2's LRs are brought on record, and others 3 to 4, 5, up to 7, up to 4 are
respondent number 1 has class 2 legal heirs.
Yes.
The appeal will not abate.
Correct, my lord. What I am submitting is that
memo,
is not brought.
File a memo, Mr.
I'll file, my lords.
The counsel for the appellant submits that he would file necessary memo or application stating out the particulars of the class 2 legal heirs of the respondent number 1. List on yavat.
Please,
don't repeat it again.
ಅಲ್ಲ DNA ಟೆಸ್ಟ್ ನಾನು ಓದ್ಕೊಂಡ್ ಬಂದಿದ್ದೆ. ಇದನ್ನ I learn the basics and I'll come forward.
Learn the basics. Really this rule applies to all cases.
I'll really take it seriously.
All cases. When you're reading an act, read it in entirety.
Please, my lords.
May I make one submission, my lord?
Next, tomorrow also, tomorrow it may be
What-
taken, my lords.
Yeah.
This
Next week, my
tomorrow.
lord. Tomorrow. Could it be
Bad
next
one.
week, my lord? So that I will
List
come.
on 15th.
15th, my lord.
16th.
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 Serial number 4.
16 or
Manjunath.
could it be 17th, my lord? 16th, I have some.
Huh?
17th, I go there.
17th. 17th, yes. D. Manjunath.
Interim order.
One request to my learned friend on the other side, my lord. One request. Class 2 ಅಲ್ಲಿ respond number 2 ಬರೋದಿಲ್ಲ, ಈಗ respond number 2 ಸತ್ತೋಗಿದ್ದಾರೆ. Let him not mention that she is there. She is dead.
No, whatever it is, now that he knows who are the class 2 heirs, let him
Of
apply
course.
his mind.
Okay. I will come on 17th, my lord.
D. Manjunath.
Number 4, D. Manjunath.
For appellant in this case.
Answer.
Respond number 1 death ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದನ್ನ ನಾವು steps ಕೊಡ್ತೀವಿ.
Respond number 1 ಯಾರು? Plaintiff or defendant?
ನಾವು appellant ಸ್ವಾಮಿ.
Respond number 1 ಯಾರಪ್ಪ? Who is the respond number 1? Appellant or defendant?
Appellant man. Respond number 1 is appellant.
Respond number 1 is the appellant. How can he be, Mr.?
Plaintiff man.
Respond number 1 is
Plaintiff.
the defendant number 1.
Please.
ಅವನು ತೀರೋದಲ್ಲ, ಮತ್ತೆ ಅವನೇ ಇಂಟರ್ಫಿಯರ್ ಮಾಡ್ತಾನೆ ಇವಾಗ.
ಎಲ್ಲಾರ್ಸ್ ನಾನು ರೆಕಾರ್ಡಿಂಗ್ ತಗೊಂಡ್ಬರ್ತೀನಿ.
ಎಲ್ಲಾರ್ಸು ಇಂಟರ್ಫಿಯರ್ ಮಾಡ್ತಿದಾರಾ?
ಹೌದು.
1 week time is granted to do the needful, failing which the appeal against the respondent number 1 shall stand. Appeal against the LRs of respondent number 1 shall stand abated.
Serial number 5, Bharat Raj
A
J.
memo is filed to withdraw the appeal. In view of the memo, the appeal is dismissed as withdrawn.
Serial number 6, Nagaraj S.
Yes, Nagaraj.
In this case, my lords, as far as the valuation is concerned, my lords, so the valuation is available at page number 49, my lords. That is the only office objection.
ಎಷ್ಟಿದೆ?
So it is 58,33,000, my lords. It has to
8
come
lakhs,
before
what?
the division bench, my lords. I have mentioned the same valuation.
So what is your share?
So, my lords, I'm the defendant.
You are the defendant.
Please, plaintiff share is 58 lakhs, my lords, totally.
Portfolio office, the learned counsel for the appellant submits that the plaintiff share in the suit shall properties is valued at a sum of rupees 58 lakhs
33,333, my lords.
333. Hence, the appeal is to be tried by the division bench.
Yes.
Office is directed to list this appeal before the division bench. Counsel for the appellant is directed to file a second set of the appeal memorandum
Filed.
along with all enclosures.
Serial number 7, MN Satraj.
1 week time may be given you. 1 week time may be given you.
ಏನು objection? Trial court case number to be stated aggrieved para, marking stating of annexures to be removed, valuation para and appeal to be stated in detail, acknowledgement for having served the copy to the other side.
ಒಂದು ಸಬ್ಮಿಷನ್ ಇವರ ಇದ್ರಲ್ಲಿ ಕೇವೆಟ್ ನೋ ಕೇವೆಟ್ ಅಂತ ಎಂಟ್ರಿ ಇದು ಓವರ್ ಸೈಡ್ ಎಂಟ್ರಿ ಆಗಿದೆ ಸ್ವಾಮಿ ಅದನ್ನು.
ಆಯ್ತು, ಇದು ಕೇವಟ್ ಇಲ್ವಾ?
ಕೇವೆಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಮಿಕ್ಕಿದ್ದಕ್ಕೆ ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಪಾಸ್ ಓವರ್. ಇವತ್ತೇ ಪಾಸ್ ಕಂಪ್ಲೈ ಮಾಡಬೇಕು.
Serial number 8, PR Srinivas Gowda.
PR Srinivas Gowda. There is no representation for the appellants today, even today. Office objections are not complied. As a last chance, list on so and so. Yavattu? 16th, failing which the appeal shall stand dismissed without reference to bench.
Serial number 9, HR Ananta Krishna Murthy.
Represent the petition. For a week's time, I must get the guideline value from 1 vara time.
What is the share?
Share 1/6.
Value of the share?
Yeah, it will come before the single judge. That's correct valuation. It will be about
1 week time is granted to do the needful.
much of it.
Serial
Mr.
number
Vishwanath
10,
Shetty.
V. Vishwanath Shetty.
A week's time.
What are the office objections, madam?
Office objections.
Court fee to be made good.
There are 7 office objections.
Uh,
Actually, some of the office
1 week
objections
time
are
is
already
granted to do
read.
the needful. 1 week.
Yes. Obliged.
Copy
Caveat is filed after filing of the.
ಆಯ್ತು, ಒಂದು ಕಾಪಿ ಕೊಡಿ ಏನಂತೆ.
Obliged.
ಶ್ರೀಧರ N.
Serial number 11, Sridhara N.
1 and 2 along with counsel submission. Exact value share of the plaintiff and plaintiff share to be.
Lordship, we have filed the valuation as per the plaint in the OS Lordship. I may be permitted to draw your Lordship attention to the valuation slip, Lordship.
ಎಲ್ಲಿದೆ?
at page 39, Lordship.
39.
Yes, Lordship. It was filed in the OS. The entire property was valued at 30 lakhs, Lordship. In that, the appellants have 1/4 share.
Then what will be the value? 7.5 lakhs.
Yes, Lordship.
Then-
In total, it will be 22 lakhs, Lordship. In page 38, we have valued it, Lordship. And we have paid the court fee of 600, Lordship, as per section 49.
For the purpose of jurisdiction, what is the value, madam? Now the property is valued at more than rupees 30 lakhs. More than is what? It can be 1 crore, it can be 10 crores. What is the value?
Lordship, that's what was mentioned in the trial court
Why
valuation.
why don't you look at what is the guideline value?
Please, Lordship.
Look at the guideline value. You are for the defendant.
The appellants, Lordship.
Appellant is a defendant or plaintiff?
Plaintiff, Lordship.
Then should you not give the correct value? Should it be listed before the single judge or the division bench? What is the jurisdiction in respect of a jurisdiction is decided under what act, madam?
Based on the value of the
No, under what act?
Karnataka State
Huh?
Court fee valuation.
No,
Act.
ಯಾವ act ಅದು? Which act?
Karnataka court fees and
ಕೊಡಿ ಅದು. ಕೊಡಿ. ಅಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ. Hey, you say you sit down. You know? Do you know it? Huh? You do not know. Let's sit down. ತೋರಿಸಿ jurisdiction ಎಲ್ಲಿದೆ ಅಂತ. ಮುತ್ತಣ್ಣವ್ರೆ, TP ಮುತ್ತಣ್ಣ, ನಿಮ್ಗೆ ನೋಡಿ. ನಿಮ್ ಜೂನಿಯರ್ಸ್ಗೂ ಸ್ವಲ್ಪ ಹೇಳ್ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಈ ತರ ಬಂದು ಹಿಂಗೆ ಹೇಳ್ತಾರೆ. There should be a brainstorming session at least once in a week. ಒಂದು ಸಂಡೇನೋ ಕಾಫಿ ಕುಡಿಯುವಾಗ ಒಂದು ಆಕ್ಟ್ ಬಗ್ಗೆ ಏನೋ ಡಿಸ್ಕಷನ್ ಮಾಡಿ ಜೂನಿಯರ್ಸ್ ಹತ್ರ. ಇಲ್ಲಾಂದ್ರೆ ಜೂನಿಯರ್ಸ್ ವಿಲ್ ಬಿಕಮ್ ಲೈಕ್ ದಿಸ್. ಏನೋ ಇಲ್ಲಾಂದ್ರೆ ಜೂನಿಯರ್ಸ್ ವಿಲ್ ಅವ್ರಿಗೆ ಇಷ್ಟ ಬಂದಂಗೆ ಬೆಳಿತಾರ ಅಷ್ಟೇ. ಯಾರೋ ಕ್ಲೈಂಟ್ ಹಿಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ, ಯಾರೋ ಕ್ಲೈಂಟ್ ಬಂದೇ ಬರ್ತಾರೆ. ಆಫೀಸ್ ಅಡ್ವೊಕೇಟ್ ಆಫೀಸ್ ಅಂತ ನೋಡಿದ ತಕ್ಷಣ ಯಾರೋ ಒಬ್ಬ ಜೂನಿಯರ್ ಯಾರಲ್ಲ ಕ್ಲೈಂಟ್ ಬರ್ತಾರೆ. ಹಾಫ್ ಬೇಕು ಅಡ್ವೊಕೇಟ್ ಹತ್ರ ಒಬ್ಬ ಕ್ಲೈಂಟ್ ಹೋದ್ರೆ ಅವನಿಗೆ ಏನ್ ರಿಲೀಫ್ ಸಿಗುತ್ತೆ? ಲಾಯರ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಇನ್ನು ಕ್ಲೈಂಟ್ಗೆ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ ಪಾಪ. ಏನಾದ್ರು ಬ್ಲಡ್ ಟೆಸ್ಟ್ ಇರುತ್ತಾ? 100% ಗುಡ್ ಲಾಯರ್ ಅಂತ ಕೊಡೋದಕ್ಕೆ ಏನು ಬ್ಲಡ್ ಟೆಸ್ಟ್ ಇರುತ್ತಾ? ಇಲ್ವಲ್ಲ. Therefore, I think you seniors should have a duty. Seniors have a duty to train youngsters. Torsimma.
Lordship, under section 35 partition shoots, Lordship. Under
Allama, civil court alladi ishtu, high court alladi ishtu valuation adu ellide adu? Under which act the jurisdiction of civil courts are determined? ನಿಮ್ಗೆ ಹೇಳಿದ ಅರ್ಥ ಆಯ್ತಾ? ಏನ್ ಹೇಳಿ?
Based on the value of the jurisdiction, which it should be before which court?
Which enactment
in which
determines or spells out the jurisdiction of civil courts? Which enactment spells out the jurisdiction of the civil courts in the state of Karnataka?
CPC, Lordship.
See, ಎಷ್ಟು embarrassing ಅಲ್ಲ? Is it not embarrassing?
CPC, Lordship.
CPC ಕೊಡಿ, ತೋರಿಸಿ ಎಲ್ಲಿದೆ ಅಂತ. Kodi. No, I will not let you go.
No, please, Lordship.
Till you learn this, I will not let you go. Kodi, CPC, Kodi. Kodi.
Lordship, if it is passed over, I'll look into
will
and
not
come and
pass
make
over.
the submission.
I will not pass over. The next time when you come before this court, at least you will be cautious and wary. ಹುಷಾರಾಗಿ ಬರ್ತೀರಾ. ತೋರಿಸಿ ಎಲ್ಲಿದೆ ಸಿವಿಲ್ CPC ಎಲ್ಲಿದೆ ತೋರಿಸಿ. This is a lesson for all youngsters in the court. Whoever is in the court, please learn from this experience.
Lordship, appeals, under appeals. Lordship. Save where the otherwise expressly section 96, Lordship, it talks about appeals from the original decree. The application was 7 Rule 11 and it was rejected, Lordship. An appeal may save the time being forced. An appeal may lie from every decree passed by any court exercising original jurisdiction, court authorized to hear appeals from the decisions of such court. An appeal may lie from the original decree passed ex parte. No appeal shall lie from a decree passed by the court with the consent of the parties. No appeal shall lie except on a question of law where the decree in any suit of a nature cognizable by courts, small courts, when the amount of the value subject matter of the original suit does not exceed 10,000 rupees.
ಮುನ್ಸಿಫ್ ಕೋರ್ಟ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಜೂನಿಯರ್ ಡಿವಿಷನ್ಗೆ ಎಷ್ಟು ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಇರೋದು? ಪೆಕ್ಯುನಿಯರಿ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಆಫ್ ದಿ ಸಿವಿಲ್ ಜಡ್ಜ್ ಜೂನಿಯರ್ ಡಿವಿಷನ್ ಎಷ್ಟಿದೆ?
Pecuniary jurisdictional
ಅಂದ್ರೆ ವ್ಯಾಲ್ಯೂ,
jurisdictional value.
ಸಿವಿಲ್ ಜಡ್ಜ್ ಜೂನಿಯರ್ ಡಿವಿಷನ್ ಮುನ್ಸಿಫ್ ಅವ್ರಿಗೆ ಎಷ್ಟಿದೆ ಜೂರಿಸ್ಡಿಕ್ಷನ್? ಪೆಕ್ಯುನಿಯರಿ ಜೂರಿಸ್ಡಿಕ್ಷನ್
5 lakhs, Lordship.
5 lakhs. ಎಲ್ಲಿದೆ ಇದು? Where do you get that?
Civil Courts Act. Civil Courts Act.
Civil Courts Act. ಯಾವ ಸಿವಿಲ್ ಕೋರ್ಟ್ಸ್? ಬೆಂಗಳೂರು ಸಿವಿಲ್ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟಾ?
No, Lordship. Karnataka Civil Courts Act.
Karnataka Civil Courts Act. See how much time you took. Somebody prompted you. The one sitting next to you prompted you.
No, Lordship. No, Lordship.
Please read, madam. Please read. When you are saying something before the court, find out what is the foundation for that. What is the basis for that? Nobody learns it overnight. You have to start from somewhere. There should be a way to learn. ನಾವು ಇದೇ ತರ ನಿಮ್ ತರನೇ ಬಂದಿದ್ ನಾವೂನು. But there's a way to learn, which you people are forgetting. ಕೊಡಿ ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ಕೊಡಿ. CPC ಹೋದ್ರಿ, ಕೋರ್ಟ್ ಫೀಸ್ ಹೋದ್ರಿ. And how many years of practice you put in?
Lordship.
How many years of practice?
6.
6 years. Waste. You spent 6 years without any labor. Sumne, you allowed 6 years to pass without any labor. Could you? ಸೀನಿಯರ್ಸ್ ಇರ್ತಾರೆ ಕೇಳಿ, ಅಲ್ಲಿ ಯಾರಾದ್ರು ಸೀನಿಯರ್ಸ್ ಇದ್ದಾರೆ, ಸೀನಿಯರ್ಸ್ ಅವ್ರ ಸೀನಿಯರ್ಸ್ ಇರ್ತಾರಲ್ಲ, ಅವ್ರೇನೋ ಈ ತರ ತಪ್ಪು ಮಾಡಿದ್ರೆ ಕೈಯಲ್ಲಿ ಬುಕ್ಕಿಗೆ ಇಟ್ಕೊಂಡು ಹಂಗೆ ಹೊಡೆದು ಬಿಡೋರು ಹಂಗೇನೆ ಅಲ್ವಾ ಮುತ್ತಣ್ಣವ್ರೆ? ಇಸ್ ಇಟ್ ನಾಟ್? ಪೇಪರ್ ವೈಟ್ ಅದು ಇದು ಏನೋ ಇದ್ರೆ ಅದ್ರ ಗ್ಯಾರಂಟಿ ಏಟ್ ಬೀಳೋದು. ಹಾ, ಇಲ್ಲ ಬುಕ್, ಪೇಪರ್ ವೈಟ್, ಪೆನ್ನು, whatever was lying on the table, it used to be the object that used to be flying in your face. ಓದಿ.
Chapter 3, Jurisdiction.
ನೋಡಿ, jurisdiction ಓದಿ.
Local limits of the jurisdiction. The state government shall, in consultation with the High Court and subject to the provisions of Section 4 and 6 of this Act, fix and may from time vary by notification the local limits of the jurisdiction of any district court or court of a senior civil judge under this Act. The state government shall, in consultation with High Court, fix and may from time to time vary by notification the local limits of jurisdiction of any court.
Go to section 18. 18 or 19.
Appeals from district court lodge. Section 18. Appeals from the decrees or orders passed by the district court in original suits and proceedings of a civil nature shall, when such appeals are allowed by the law, lie to High Court. When the courts conferred, there's a case law also cited, Lordship. When a courts are conferred jurisdiction under Hindu Marriage Act, they must be construed by as exercising powers of the district court, and hence the appeal should lie to the
single bench ಮುಂದೆ ಬರಬೇಕು, ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಬರಬೇಕು ಅನ್ನೋದು ಇಲ್ಲಿ ಇರುತ್ತೆ.
That amounts to the subject matter value of
ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಬಂದಾಗ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಹೈಕೋರ್ಟ್ ಬರಬೇಕು. ಸಿವಿಲ್ ಜಡ್ಜ್ ಸೀನಿಯರ್ ಡಿವಿಷನ್, ಇಫ್ ದ ವ್ಯಾಲ್ಯೂ ಇಸ್ ಮೋರ್ ದನ್ 10 lakhs, it has to come to the ಹೈಕೋರ್ಟ್. ಹೈಕೋರ್ಟ್ ಬಂದಾಗ should it go before the single judge or the division bench ಅಂತ ಎಲ್ಲಿದೆ? ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಹೋಗ್ಬೇಕಾ, ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಹೋಗ್ಬೇಕು ಅನ್ನೋದು ಎಲ್ಲಿ ಸಿಗುತ್ತೆ?
ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್. ಹೈಕೋರ್ಟ್ ಕೋಡ್ ಆಫ್ ಆಕ್ಟ್.
ಹೈಕೋರ್ಟ್ ಕೋಡ್,
ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಆಕ್ಟ್.
ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಆಕ್ಟ್ ಅದರಲ್ಲಿದೆ, ತೆಗೀರಿ ಕೊಡ್ರಿ.
Lordship, appeal from first appeals. All the first appeals against the decree or order passed in a suit or the other proceedings, the value of the subject matter of which exceeds 15 lakh shall be by the bench consisting not less than 2 judges of the High Court.
ಅರ್ಥ ಆಯ್ತಾ ಈಗ? ಎಷ್ಟಿದೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ನಿಮ್ದ್ರಲ್ಲಿ?
Lordship, valuation
30 lakhs and more. 30 lakhs and more could be 5 crores, it could be 10 crores, it could be 100 crores.
Yes, Lordship.
So should you not mention what is the valuation for the purpose of considering whether it should be listed before the single judge or before the division bench?
Please, Lordship, I may be permitted to draw your Lordship attention to page 29 where I have filed the valuation.
So ಅದಲ್ಲಿ ಎಷ್ಟು ಅಂತ ಹೇಳಿದಿರಾ?
ಅದರಲ್ಲಿ appellants have calculated their each share before the court as 7,50,000, Lordship.
ಎಲ್ಲಿದೆ?
At page 29, Lordship.
7 lakhs ಅಂದ್ರೆ ಎಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಅವಾಗ?
Less than 15 ಅಂದ್ರೆ it is before the single judge.
ಅದಕ್ಕೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ಓದಿ ಇನ್ನೊಂದ್ಸತಿ.
Does not exceed 10 lakhs.
ಹೈಕೋರ್ಟ್ಗೆ ಅಪೀಲ್ ಬರೋದು ಯಾವಾಗ?
Shoot is not basis. Exceeding 10 lakhs, Lordship.
So if it is below 10 lakhs, ಯಾರಲ್ಲಿ ಹೋಗ್ಬೇಕು?
District, senior.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು.
Senior.
ಮತ್ತೆ ಇಲ್ಲಿಗೆ ಹೆಂಗ್ ಬಂದ್ರಿ? How can you come here to the High Court, madam? You have to go before the district court. Pass over, ನೋಡ್ಕೊಂಬನ್ನಿ clean ಆಗಿ.
Lordship.
You only labor, put your labor. ಸ್ವಲ್ಪ effort ಹಾಕಿ. Don't go and ask seniors.
No, sir.
No, let us see how well you fare.
Grateful, Lordship.
Serial number 12, Ravi Shankar S.
Ravi Shankar, yes. Awaiting service of notice. List after service of notice to response 1 to 3.
Serial
Mr.
number 13.
Muttana.
Serial number 13, TP Muttana.
My lord, this matter pertains to debt recovery, my lord.
Pertains to?
Debt recovery. Here what happened, my lord? Respondent number 2 availed the loan. And that is and in the year 2013.
Respondent number 2.
Respondent number 1, Manjula Devi. And 2008, she sold the same property to some respondent number 4. And that without suppressing that, then she availed the loan because it is not registered, unregistered agreement. Then that bank, then that she became defaulted and bank has initiated action under Surface Act, Section 3, demand notice, and ultimately property was sale notice was published. When the sale notice was published, respondent 4 wrote a letter to the bank. No, this property, because earlier there is an agreement, I filed a suit before the civil court, and hence that there already the decree is there. Then this property, entire property is being sold. Then, my lord, then bank filed one. This has all happened during the execution petition. Then bank filed an application as an objector, stating that bank has got the interest, security interest has been created, and entire property is mortgaged to the bank. Bank was not knowing, and that application was rejected, stating without giving the reasons, because we have quoted that provisions of section.
No, what was this decree for?
Decree for money decree.
Money decree.
Money decree. And my lord, then that for money, and they opted for money decree.
Refund was ordered.
Yes, my lord. Now, my lord, the entire amount is lying before the civil court. Property TPR sold for 2 crore 70 lakhs. My only request, this prayer is, my lord, to keep this bank's 94 lakhs set apart till it is decided. Because the rejection of our as an objector itself is wrong.
What was your liability?
Our liability total 94 lakhs.
94 lakhs. And property sold at 2 crore
2.74, 2 crore 70 lakhs they have already sold. Some more properties that they have already that were selling this May.
ನಿಮಗೆ ಎಷ್ಟು ಬರಬೇಕಾಗಿರೋದು? ಮಿಕ್ಕಿದ ತಗೊಳ್ಳಿ ನೀವು ಅಷ್ಟೇ.
ಅದಕ್ಕೆ ಅಷ್ಟೇ ನಮ್ದು ಪ್ರೇಯರು ಜಸ್ಟ್
ಕರೆಕ್ಟ್ ಅಪ್ಪ. ಇವಾಗ ಬ್ಯಾಂಕ್ ದಿಸ್ ಇಸ್ ಅ ಪ್ರಯರ್ ಚಾರ್ಜ್ ಆಫ್ ದ ಬ್ಯಾಂಕ್. There is a prior charge in favor of the bank. Bank has sold it. ಇಲ್ಲ ನೀವೇ
ನಾವು ಸೇಲ್ ಮಾಡಲಿಲ್ಲ.
ಒಂದು ಕೆಲಸ ಮಾಡಿ, ನೀವೇ 279 ಕೊಟ್ಟು ತಕೊಂಬಿಡಿ ಪ್ರಾಪರ್ಟಿನ. ಆಯ್ತು, ನೀವೇ ತಕೊಂಬಿಡಿ. ಕರೆಕ್ಟ್, ನೀವೇ ತಗೊಳ್ಳಿ ಪ್ರಾಪರ್ಟಿ. ಅಟ್ ಲೀಸ್ಟ್ ಯು ಪೇ ದಿಸ್ 2 crore 79 lakhs. ಪರ್ಚೇಸರ್ ಯಾರು?
ಅಲ್ಲ, they have to pay me only 94 lakhs.
ಆಯ್ತು, ಪರ್ಚೇಸರ್ ಯಾರು? ಪರ್ಚೇಸರ್ ಯಾರು?
Respondent number 4. Respondent 4 is the now that money.
Auction
ನಾವು ಸೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಮ್ಮನ್ನು ಸೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಿಡ್ಲೇ ಇಲ್ಲ. Civil court says
sold.
No, that court has sold. On the basis of the decree, court has sold for 2 crore 70 lakhs. That money is lying with the court.
Oh, court has sold it.
Court has sold, my lord. ಸೇಲ್ ಆಗಿದೆ, ನಾವು ಬರ್ದಿದ್ದೇವೆ 2 crore 70 lakhs ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಅದು ಒಂದು ಪ್ರಾಪರ್ಟಿ ಆಗಿದೆ, ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಆಗಲಿಲ್ಲ.
17th ಗೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. So anyway, you will have a prior charge for that 93 lakhs that you have. Is there a recovery certificate for 93 lakhs? 93 lakhs.
93 lakhs, yes, my lord.
Recovery certificate idea. Make a claim. Why are you coming in the way of the property being sold?
No, that property, my lord, you are not coming the way. Only thing is, our 94 lakhs was recovered and property has already been sold. Now I think he's selling is
He's
not.
saying that the property is
No,
not
I have
sold.
written there.
Sale ಆಗಿಲ್ಲ ಅಂತ
In the
ಹೇಳ್ತಿದ್ದಾರೆ.
ನಾಳೆಗೆ ಒಂದು ಸ್ವಲ್ಪ ಹಾಕಿ. Today I will check up now. Tomorrow.
Find out whether the property is sold or not.
Yes, ma'am.
If it is sold, then you make a claim for 93 lakhs before the executing court. The
But
court will decide.
No, our prayer in the objector only that only. But he says, no, your objection, this you have come very late, hence rejected. That's all, my lord.
Next. List tomorrow.
Serial number 14, Guttal Sivappa Shankarappa.
List after service of notice to R1.
Interim order में kind.
Interim order granted early is extended till the next.
Serial number 15, Nagaraj Shetty.
Nagaraj Shetty. Nagaraj Shetty.
Lord, may I appear? There is only one office objection that one Basappa is dead, his legal representatives are already on record. This is a case of rejection of a plaint. Lord, suit is based upon a sale agreement dated 15/4/97.
15/4/97.
3 lakhs is paid, Lord, as on that day. Possession is delivered. Agreement says 11 months time. But nothing happened thereafter. On 16/7/2006, 10 lakhs is paid and he receives 16/7/2006. 10 lakhs is paid. On 16/10/2008, notice is issued calling upon him to execute since he has received the entire consideration. Then on 7/11/2008, he gives a reply denying the agreement itself. Now we file a suit, Lord, on 18/10/2010. Now, after the case is posted for defendant evidence, in the year 2025,
where is the plaint?
Blood plaint is at page 40, 49, 43 onwards starts.
MS Raghunandan. ಕೇವಟ್ ಹಾಕಿದಾರಲ್ಲ
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀಯ? ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರ?
ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಸರ್ವ್ ಆಗಿದೆಯಾ? Para 12, 13, 14, that receipt is also produced, Lord, at page. Our case is, he receives 10 lakhs and denies the agreement and our cause of action arises, Lord, from the date of denial.
10 ಲಕ್ಷ ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು?
10 ಲಕ್ಷ is received on, receipt is on 16/7/2006, page 55.
Page 55.
Yeah.
55 ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
55. There is an agreement which starts from page 52, separate ಆಗಿ ಹಾಕಿದ್ದಾರೆ.
ಈಗ 55 ಇಲ್ಲ ಇಲ್ಲಿ.
ಬೇರೆ ಹಾಕಿ ಮೆಮೊ ಜೊತೆಗೆ ಹಾಕಿದ್ದೀರಾ?
ವಕಾಲತ್ is 53.
ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ, ಏನು ಸಪರೇಟ್ ಆಗಿ?
List of documents.
ಇದರಲ್ಲಿ ಒಪ್ಕೋತಾರೆ, ಹಳೆ ಕರಾರಿಗೆ ಒಪ್ಪಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಕೊಡುತ್ತೇವೆ ಎಂದು ಒಪ್ಪಿ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದ್ರು. 13 ಲಕ್ಷ ರಿಸೀವ್ ಮಾಡಿ.
Yes, Mr. Raghunandan. ಪಾಸ್ವರ್ಡ್ ಬರ್ಲಿ
ಆಯ್ತು.
ಪಾಸ್ವರ್ಡ್.
Serial number 16, EI Sanmati.
Mr. EA Sanmati.
Appear for the appellant.
In R2 to R8, await.
Your Lordship, the contesting respondent is only bank, not others have accepted the judgment, not they are not before this honorable court, they have not filed independent appeal.
R2 to R8 ಮೇಲೆ you don't press the appeal.
They are, Your Lordship, I am challenging the judgment dated 2021, my lord.
Who are R2 to R8?
Your Lordship, borrower, my lord, it is relating to a housing loan, my lord. The borrower, builder and another one guarantor are the other parties.
So only respondent is the contesting respondent.
Contesting respondent, my lord.
Barkoli. We run counsel for the The learned counsel for the appellant submits that the respondent number 1 is the only contesting respondent, and therefore this appeal may be taken up for consideration of the interim relief.
Same, my lord.
Yes, what is this?
Your Lordship, this is a suit for recovery, my lord. Your Lordship, the first respondent is a bank, my lord. Your Lordship, I am one of the guarantor. Your Lordship, the second respondent approached the bank along with the builder. There was a tri-party agreement relating to purchase of one flat. On the basis of that, some amount was directly released by the bank to the builder. Your Lordship, there was a title dispute, my lord, and therefore there was a title dispute. The amount could not be repaid by the borrower. Your Lordship, since there was a default, the bank filed a suit for recovery. And during the pendency of the case, there was the attachment before the judgment.
Attachment of what?
Attachment of the flat, my lord.
No, it is already conveyed.
Construction was already complete, my lord.
But in a sale agirlwala.
Sale agirlila, but there was an attachment regarding the scheduled property. Your Lordship, that order was subsequently vacated on the ground that there were other two persons came to intervene in the suit and said that the property belongs to them. Your Lordship, against that, the court vacated the order. Against that, a bank filed MFA before this honorable court. MFA was withdrawn. Subsequently, the suit was decreed against the borrower, builder, and guarantor. I am the guarantor. Your Lordship, as per the tri-party agreement, there is a specific clause in the agreement that if there is any violation relating to any event, if there is title is not perfect, then the builder will indemnify. Builder will indemnify, my lord. There is specific clause.
My lord, I may be permitted to file objections on their IA for condonation of delay.
There is a clause in the tripartite agreement that in the event.
No, we'll bring all that in the objections to be filed before this honorable court, my lord.
They just find out a few days back, I decided one case where Suman Hegde, she had appeared in that matter. Just check that.
And my lord, may be directed to serve the entire copy of the appeal memorandum.
Copy, sir.
Lordship, entire copy served to your colleague.
And
that trial court execution advocate served it and got the appeal. Anyhow, I will serve one more copy.
Please.
What is the interim order that you have sought for?
Your Lordship, there is execution, my lord. Attachment warrant has been issued of movables and immovables, my lord.
Just don't execute the order.
My lord.
Don't execute that order.
Please,
as against the guarantor.
Please.
Or cool. Delay is
delay of 1751 days, my lord, because the judgment was pronounced in 2020. And after that, my lord, there was a negotiation going on between the borrower and the bank. They have not settled it. Only in 2025, I came to know about the execution.
In consideration of IA number 1 of 26 for condonation of delay, the further proceedings, the execution of the attachment of movables passed by, in which court? Passed by so-and-so in EP number so-and-so is stayed in so far as the appellant is concerned.
Much obliged.
Great, my lords.
Next week for the
list on yavat beko told.
Next week, next
Take
16.
Mr. Mudduraj.
Serial number 17, C. Mudduraj.
For the appellant, my lord. There was a error in registering as RFA. It is a commercial appeal, my lord.
Barkul, the learned counsel, the officers raised an objection that an appeal under section 96 of CPC is not maintainable as the appeal arises out of a decree passed by the commercial court. Therefore, the learned counsel for the appellant seeks liberty to convert this appeal into a commercial appeal.
Yes. Only
office is directed to renumber this appeal as commercial appeal for statistical purposes, this appeal is treated as closed.
Much.
Counsel for the appellant is directed to make appropriate corrections to bring it in line with the format of an appeal, format of a commercial appeal.
Only name has to be changed. Adonde bittogide sir.
Adanne correction ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Much obliged.
For hearing on serial number 18, Irshad Ahmad.
Irshad Ahmad, Tajuddin.
Case wherein I am representing the respondent.
Any objection to bring the legal aids of the appellant on record?
I don't know. I am not at all appearing. Last 2023, I have filed a case. Thereafter, I don't have any knowledge about the case.
Yes, Barkul.
I happen to see DD.
Barkul, IA 3 of 26 is filed by the applicants for condonation of delay.
I don't
On
have
the
any copies.
condition of delay.
I was not appearing earlier.
ಇವಾಗ ಅಟ್ಲೀಸ್ಟ್ ಕಾಪೀಸ್ ಕೊಟ್ಟಿದಾರ ಇಲ್ವೋ?
ಅಲ್ಲ ಏನು ಕೊಟ್ಟಿಲ್ಲ ನಂಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ. 23 ಅಲ್ಲಿ caveat
ಏನ್ ಮಿಸ್ಟರ್
I have sent the copies by post.
ಆಯ್ತು ಸರ್, ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ ಸರ್.
ಕೊಡ್ತೀನಿ ಸರ್. ಕೊಡ್ತೀನಿ.
ಯಾವತ್ತಿಟ್ಟು?
1 to 6 ಏನಿದೆ?
ಆಯ್ತು, when should I have it? Tomorrow?
Tomorrow.
List
I will
tomorrow.
furnish a copy today itself.
Please do it today itself.
Agli sir.
Number 19, Amrish A. Angadi.
I am appearing for the appellant, my lord. My lord, I made application to preparation paper book.
IA 126 is filed by the appellant for preparing for a direction to the paper book branch to prepare the paper book.
Please, my lord. All the appeal same, my lord.
Injunction is decreed against which appeal is filed.
ಎಷ್ಟಿದೆ exhibits?
Near about 25, 26 of those.
What are the nature of exhibits?
My lord,
Lease cum sale, possession, khata, receipt.
Land is acquired, notifications, and sale deeds, allotment letters in my favor.
ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ. Since the oral and documentary evidence is minimal, filing of paper books is dispensed.
Please, my lord.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
The respondents are all allottees from the society.
ಯಾರು ಶಿವಪ್ಪ ಅಂತಿದ್ದಾರೆ.
Adರಲ್ಲಿ I take wakalat, this one plus.
You will accept notice. You will accept notice.
Yes, but I accept. For others, other plan already there.
Mr. Prakash, full list, you know, BS. BN Prakash accepts notice for the appellant, respondent in serial number 19 Alma. Office is directed to show his name in the cause list. Counsel for the appellant is directed to furnish a complete set of the appeal memorandum along with all enclosures to Mr. BN Prakash.
Interim order be continued, my lord.
Interim order is granted early as extended to the next date. 19.1, 19. ಎಲ್ಲದಲ್ಲೂ same order ಮಾಡಿ.
Same order.
Up to 19.4 ಅಲ್ಲಿ paper book filing of papers is dispensed. Yes. All interim orders is extended. List for final hearing. ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಯಾವತ್ತು ಬೇಕು? ಯಾವತ್ತು ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ. Since the filing of paper books is dispensed, IA 126 stands disposed of. A list for final hearing on 17th or 24th.
After vacation, my lord. After vacation, my lord. I will not be in the station.
ಏನೋ ನೋಡೋಣ, ಏನಾದ್ರೆ ಮಾಡೋಣ. Yes, next. Gopi GA.
Number 20.
Sorry. Tomorrow I will not be in this station. Maybe day after.
Day after tomorrow is Saturday.
Day out of station.
ಲಿಸ್ಟ್ ಆನ್ ಯಾವ್ದು ಬೇಕು ಕೊಟ್ರಿ. ಯಾವತ್ತು ಬೇಕು ನಿಮಗೆ?
ನಾಳೆ ಬಿಟ್ಟು ಯಾವ್ದಾದ್ರು
ಕೊಡ್ರಿ.
16th April. 16th April.
Gopi GA.
I have instructions and appearance for the appellant.
Yes.
Application has been
Case, my lord, I am filing objection to the IA that 265 days delay in filing the appeal.
ಏನು reason, Gopi?
Court of sale.
Application has been filed, my lords, in the said affidavit, my lords. They have pointed out, my lords, that there was some shuffling in the administrative and legal department, my lords. Immediately they could not secure instructions and also get the person to file the wakalat and to take steps for handing over the matter to the concerned counsel for filing of the appeal. Thereafter, my lords, they have filed the appeal and they have come back to the court. There is some delay, my lords.
IA 1 of
Objection may be
25 is
taken
filed.
as record.
IA 1 of 23 is filed seeking condonation of delay of 263 days in filing the appeal. It is stated in the affidavit accompanying the application that the advocate on the panel of the appellant who was handling the suit before the trial court informed the appellant about the disposal of the suit on 6/7/2022. They stated that there was shuffling in the administrative and legal department, and therefore there are no officers authorized to sign the wakalat and hand over the file to the counsel on record to prepare and file an appeal to challenge the judgment and decree of the trial court. It is also contended that the counsel who handled the suit who defended the suit before the trial court did not furnish all documents, and He therefore could not furnish all the records to the counsel on record in this appeal to prepare the appeal in time and file it in time. Full stop. After securing all the records, comma, it is stated that the appeal was filed, although belatedly. Full stop. It is therefore contended that the appellant had admitted that the advocate representing the appellant before the trial court had informed the appellant about the disposal of the suit on 6/7/2022. Therefore, it had knowledge about the disposal of the suit on 6/7/2022 itself, and hence it must have filed the appeal within time. So it is also contended that the contentions of the appellant that they were shuffling in the administrative and legal department is a vague and bald statement without any particulars. Full stop.
Rest of the things denied.
Hence, it is contended that the reason assigned by the appellant for not filing the appeal in time is not justified, and the delay caused in filing the appeal cannot be condoned. Next para. The appellant is an authority constituted under the provisions of the Bangalore Development Authority, which has an administrative and a legal team to defend litigation against it. Full stop. The appellant has candidly accepted the fact that it came to know about the decree about the disposal of the suit on 6/7/2022 itself. However, it is claimed that due to shuffling of the administrative and legal department, there was no proper officer who was authorized to sign the papers. In addition, it is contended that the advocate who defended the authority before the trial court did not have all the papers, and therefore the advocate who represented the appellant in this appeal could not file the appeal in time. The reason assigned, is not unbelievable, but is probable and deserves to be accepted. Consequently, the delay caused in filing the appeal is condoned.
Kindly see, my lord. Insofar as prayer is the judgment is concerned, my lord. ಕಾನೂನಲ್ಲದ ರೀತಿಯಲ್ಲಿ ಮಾಡೋದು ಬೇಡ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Suit is for injunction.
Suit for injunction. Page number 34 may kindly.
ಏನು injunction ಕೇಳಿದಿರಿ?
Injunction restraining them to demolish my building. Without the court decrees the suit unless due process of law that they cannot demolish the building.
Recovery proceedings anta ide. I saw that this.
That is what
recovery proceedings.
Restrained not to interfere with the possession of the plaintiffs or the suits unless and until they could initiate recovery proceedings in accordance with
this matter, my lords, it's an acquired property. One. Secondly, my lords, already action was initiated way back in 1993 itself for removal of the unauthorized constructions. At that point of time, they had filed writ petition also. Therefore, my lords, it would be a case, my lords, for removal of encroachment, my lords, not for recovery proceedings for filing of a suit, my lords. Perhaps it could come under the Public Premises Act.
Take action under the Public Premises Act.
So clarify that position, Lord, I'll also not.
Can dispose of the appeal.
So that we can take action immediately.
In accordance with law.
This appeal is filed by the defendants in OS number 665 of 2015, BD Act 2015.
One request, Lords, before
challenging the judgment and decree dated.
I'm sorry, Lords, one request I wanted to make, Lords. There are some points which have been noted, my lords, that as regards the initiation of acquisition itself, the trial court disputes, stating that there is no mention about the total extent that's been acquired. That is an incorrect finding.
Then we'll have to go through the merits.
Please, I'll make my submissions on the next date. I'll point out that one aspect.
Yes. List for admission on date could.
15th or 16th.
There's a provision under the BD Act for
33 months.
Recovery of possession.
Section 33.
If at all that they have acquired.
I'll point out that one. That's the reason.
They can recover possession of a property which belongs to them.
Please.
There is no dispute.
15th or 16th, my lord. 15th or 16th.
Jayalakshmamma KB.
This is suit for recovery of money, my lord, on the promissory note, my lord. There is a delay of 397 days, my lord. explanation, the supporting affidavit.
Suit is for recovery of money, mister.
Yes.
Yes, what is the reason, madam?
Reason, my lord, after the decree, my lord, they have filed execution petition, my lord. Thereafter, my lord, I have filed the.
Oh, really?
Thereafter, my lord, I have filed this appeal, my lord. In the execution petition is stayed, my lord, by filing writ petition, my lord.
Execution is stayed.
Stayed, my lord.
ಎಲ್ಲಿದೆ ಅದು?
Execution petition, my lord.
ಅಲ್ಲ, writ petition ಎಲ್ಲಿ stay ಆಗಿದೆ?
Stay ಆಗಿದೆ. Writ petition number 6033 of 25.
6033
of 25.
That was filed by you?
Yes, my lord.
On what ground?
My lord, in the execution petition, my lord, directly they have issued arrest notice, my lord, and that without issuing notice nor attachment of mobiles, my lord, directly the trial court has issued arrest warrant, my lord, that has been stayed, my lord.
Please understand, mister, if you admit the appeal, you will get 50% of the amount.
Already I have. Already I have subject to deposit to 1 lakh I have already deposited.
ಇವಾಗ ಅಪೀಲ್ ಬಂದ್ರೆ ಇನ್ನೊಂದು ಲಕ್ಷ ಹೇಳ್ಬೋದಲ್ಲ?
ಅಮೌಂಟ್ ಇರೋದೇ 3 lakhs.
ಹೊಟ್ಟೆಲ್ ನೀರು ಅಲ್ಲಾಡದೆ ನಿಮ್ಗೆ 2 ಲಕ್ಷ ಬರ್ತಾ ಇದೆ.
ಅಲ್ಲ, ಅವರು vacating.
Without shaking a leg, you are going to get 2 lakhs.
In the writ petition, they have filed vacating application.
ಬರ್ಕೊಳ್ಳಿ. IA 1 of 25 is filed for continuation of delay of 394 days in filing the appeal. It is stated in the affidavit accompanying the application that after the decree was passed by the trial court, an execution petition was filed by the respondent in EP number 11/2025, where an arrest notice was issued to the appellant. Full stop. This was questioned by the appellant in WP number 6033 of 2025 before this court, where an order of stay is granted. Full stop. In the meanwhile, the appellant was advised to file an appeal challenging the judgment and decree of the trial court, and therefore the appeal was filed belatedly. Full stop. The application is opposed. Objection hakidiri? Opposed orally by the learned counsel for the respondent, who submits that that the affidavit accompanying the application does not contain any reasons justifying the delay in filing the appeal. He therefore submits that the application does not merit consideration. Next para. The learned counsel for the respondent has not disputed the fact that that EP number 11/2025 is filed to execute the judgment and decree passed by the trial court, where an arrest notice is issued to the appellant, which was challenged by the appellant in WP number 6033 of 2025 before this court, where there's an order of stay. Full stop. Therefore, it is quite possible that the appellant was thereafter advised to file an appeal challenging the judgment and decree passed by the trial court. Full stop. In that view of the matter, the reason mentioned by the appellant for not filing the appeal in time deserves merits acceptance. Consequently, IA 1 of 25 is allowed, and the delay of 394 days in filing the appeal is condoned. List the appeal for admission on tomorrow.
Next weekend.
Great. Good. Yeah, good.
17th.
Yes, Mr. Rigo.
Serial number 22. Rigo LP.
Lord, this matter, I'm filing a memo for withdrawal, my lord.
A memo is filed by the learned counsel for the appellant to withdraw the appeal. The memo is taken on record and the appeal is dismissed as withdrawn. Any refund? No. Yes, next.
They filed, my lord, liberty to grant refund, my lord, because what had happened, my lord?
How much have you paid?
36,000, my lord. What had happened, my lord, is they were not made parties in the lower court.
Office is direct to refund the court fee in accordance with the judgment of the apex court in the case of so and so.
Much obliged.
All pending applications stand disposed of. Prakash Hebbar.
Serial number 23.
Issue notice on IA 1 of 25 as well as in the main appeal. 24 same order. 25 same order. 26 same order. 27 same order.
25 to 27, my lord. The respondent number 11 to 56 are the formal parties, my lord, because they are the.
Memo kodi. A memo is filed by the learned counsel for the appellant seeking dispensation of notice to respondent number
11 to 56, my lord.
11 to 56.
And my lord, the connected site owners also filed RFA. It may be linked
issue
with
notice to the respondents 1 to 10. on IA number 1 of 25 as well as in the main appeal. List along with RFA number.
RFA number 3 appeals.
Yes, number 28.
Correct.
28.
Chandrasekhar. Appellant ಈ ಕಡೆ ಬರ್ಬೇಕು.
Needs complying the obvious objection to kindly to.
Who are you?
I am appealing for the appellant in trial court. Not a proceeding that.
Mr. Who are you ಅಂದ್ರೆ appellant ಅಂತ ನಂಗೂ ಗೊತ್ತು. Appellant ಯಾರು?
Subsequent purchasers.
ಹಂಗೆ.
Please.
Who are you ಅಂದ್ರೆ appellant. Appellant ಯಾರು ಅಂದ್ರೆ ಅವ್ರ ಹೆಸರು ಹೇಳ್ತಾರೆ. ಅವ್ರ ಹೆಸರು ಹೇಳಿದ್ರೆ ಅಪ್ಪನ ಹೆಸರು ಹೇಳ್ತಾರೆ. You are a subsequent purchaser.
Yes.
After the suit or before the?
No, after the suit, sir. After the suit, we have not knowledge of the file the OIS, and then the knowledge of the appellant come and the FDP final degree proceedings.
If you purchase the property after the suit, what is your right to challenge the judgment? What is your right? Suit is contested or not contested?
No, not contested.
Suit is not contested.
No, not contested. Not party to proceedings also here.
Allappa, trial court expiry decree na?
Expiry decree.
What is your defense then?
We have the challenging the.
What is your defense? You are not a member of the family.
Please, sir.
You are not a member. Please. So how can you comment about the defendants, whether they are members, not members, whether they partition, no partition? As a subsequent purchaser,
yes,
what is your right?
I'll address the next letter. I'll address the next letter.
You will address arguments, sir?
Yes, sir.
Chandrasekhar.
And so I am a subsequent purchaser in the matter. 2014 was the suit for partition. It was self-acquired property of the father. 2014, he actually gifted the property in favor of the children, means sons. Daughter filed the suit later.
So the father gifted the property to the sons.
Sons,
and you have purchased from the sons.
From the sons. He suppressed that fact and filed the suit. And we were placed ex parte. Father as well as the daughters were placed, sons were placed ex parte.
Where is the gift deed?
Page number 67, 65, my lords. Annex E.
Sridhar Naidu.
Please, my lords.
Sridhar Naidu. Sumangala.
Please.
Sunil yes and Anil yes.
Please, my lords. I purchased the property at page 85. 2021, I purchased the property.
Whether the plaintiff has mentioned anything about the gift deed?
My lord, she did not mention. No, my lord. After 7 months, the gift deed was executed. After filing the suit, the gift deed was executed, my lord. Sorry. February was the suit filed, and September was the gift deed, my lords. September was the gift deed.
Barcode. Issue notice on IA 2 of 26 as well as the main appeal. FDP ಹಾಕಿದಾರಾ?
Please, my lord.
Drawing up a final decree is state. However, all proceedings up to the final decree shall continue.
Please, oblige.
But you can't read this much. ಇಷ್ಟೇ ಯಾಕೆ ಓದ್ಕೊಂಬರಕ್ಕಾಗಲ್ಲ? ಒಂದು 3 ಡೇಟ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಸೂಟ್ ಆದ್ಮೇಲೆ ಪರ್ಚೇಸ್ ಮಾಡಿ ನಿಮಗೆ ಸೇಲ್ ಆಗಿದ್ದು 3 ಡೇಟ್ ಬರ್ಕೊಂಬರಕ್ಕಾಗಲ್ವಾ? Is your colleague or you have been engaged?
My colleague only, my lord.
ಇಲ್ಲ 2 ನಿಮಿಷ ಕೂತಿರ್ತೀರಪ್ಪ, ಆಫೀಸ್ ಕೋರ್ಟಲ್ಲಿ ಕೂತಿರ್ತೀರ, 2 ಹಿಂಗ್ ತಿರುಗಿಸಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
Much obliged.
Yes. ಇದೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅಂತ ನೋಡಿ.
In the meantime, I'll comply.
In the meanwhile, office objection shall be complied. Yes.
Oblige.
Subramanya Upasana.
In this case, Minister.
Appeal.
29.
Appellants purchased the suitable property before the institution of suit mailers in the year 2014 mailers. 2020 they filed a suit for partition The partition suit is ex parte
Barcode
decree,
IA,
my lords.
issue notice on IA 3 of 2026 as well as in the main appeal. Office objection in the office objection shall be complied with the next date of hearing. In the meanwhile, comma, the final proceedings, final decree proceedings, if any,
Final decree
final decree
proceedings.
in the meanwhile, drawing up a final decree is stayed. However, all proceedings up to the final decree shall continue. Correct.
List number 2 matters. Serial number 1 for order, serial number 1 NS Sriraj Gowda.
Notes ಅದ್ರಲ್ಲಿ ಫೈನಲ್ ಡಿಗ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಿನ್ನೆ ಡ್ರಾ ಆಗಿದೆ ಅಂತೆ. ನಿನ್ನೆ ಫೈನಲ್ ಡಿಗ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡ್ರಾ ಆಗಿದೆ ಅಂತೆ.
ಫೈನಲ್ ಡಿಗ್ರಿ ಆಗಿದೆಯಾ?
ನಿನ್ನೆ ಆಗಿದೆ ಅಂತೆ.
Stay of all further proceedings. Stay of all further proceedings in FDP number. FDP number so and so on the file of so and so.
120/2016, my lords.
Stay of the final decree, if any, drawn in FDP number
120 of 2016
on the file of
district city
yes.
10th additional city civil judge at Bangalore.
Yes.
Oblige. Sorry, my lord.
Yes. Sriraj.
Stay applications. May I request, my lord, that your lordship have this matter next week. This is an offense, my lords, that it's of 302. My lords, the lower court rejects it. My lords, this honorable court rejects my application. It's upheld by the Supreme Court, my lords. Now
upheld in the Supreme Court
upheld
also.
in the Supreme Court. Now, my lords, again a bail petition is filed before the lower court. My lords, again it is rejected. I am before your lordship.
What is the change circumstance?
My lords, charge sheet was not filed then. Charge sheet was filed. My lords, but I have not gone through the entire file. Lordship may have it next week.
Learn counsel for the appellate petitioner seeks time list on yavattu
17th or
so and so date. Yes.
Grateful.
Karthik N.
Serial number 2 Karthik M.
ನೆನ್ನೆನೂ ಬಂದಿಲ್ವಾ? ನೆನ್ನೆ ಮ್ಯಾಟರ್ ಅಲ್ವಾ ಇದು? ಇಲ್ಲ ನೆನ್ನೆನೂ ಕಾರ್ತಿಕ್ ಅಂತ ಬಂದಿದ್ರು. ಎಸ್ ಕಾರ್ತಿಕ್ ಎನ್.
Serial number 2 Karthik N. List number 2 matters.
ಮೇಡಮ್ ಹಾಕಿ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಹಾಕಿ ಮಿಸ್ಟರ್ ಕಾರ್ತಿಕ್ ಎನ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಇನ್ ಪೋರ್ಟಲ್ ನಂಬರ್ ಸೌಂಡ್ಸ್ ಅಂತ ಹಾಕಿ. Yes, government, what is the offense?
My lord, IT Act, my lord.
IT Act.
Yes, my lord. It is relating to a billing software, my lord, and data backup, which through WhatsApp he was working in that company. ಆ ಕಂಪನಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಬೇರೆ ಕಂಪನಿಯವರಿಗೆ he has transferred that software, my lord. And confidential data of the company also. Along with the A1, my lord. He is A2, the petitioner is A2.
ಆಯ್ತು, if his presence can be secured ಮಾಡ್ಬೋದಲ್ಲ. Everything is there is no question of tampering ಮಾಡ್ಬೋದಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. This is a petition filed under section 439 of CRPC. Sorry. This is a petition filed under section 438 of CRPC and presently section 482 of BNSS seeking anticipatory bail in crime number 286 of 2025 registered by the West Sen Crime Police Station, Bangalore City for offences punishable under section 66 and 66C of the IT Act 2000 and section 318(4) of BNS 2023. Full stop. Briefly stated, the case of the prosecution was that the accused number 1 allegedly indulged in unauthorized access and copying of business data of one retail RO store andrenu?
Company.
RO store andre?
That is the company, this thing.
It's not RO store at Chennai. From the RO store at Chennai's Vyapar Billing Software. Full stop. The petitioner was arraigned as accused number 2. In view of since he was an old customer, an old customer informed the complainant that RO Store's Chennai data was with the petitioner's company and that the accused number 1 had sent it to a contact of the petitioner and that the petitioner therefore had notice and knowledge of the activities of the accused number 1. Full stop. Based on such an information, the respondent number 1 registered crime number 286 of 2025 for the aforesaid offences and initiated and commenced investigation. So the petitioner filed a petition under section 439 before the district court, which was rejected in terms of an order dated 22/8/2025. The petitioner is therefore before this court. Next, the learned counsel for the petitioner submitted that a perusal of the information furnished by the complainant before the respondent number 1 would show that the petitioner was arraigned as an accused based on a suspicion that the petitioner, being the director of Water DNA Private Limited, was accessing the RO Store Chennai data from 1 to 1.5 years prior to the date of the crime, and that he had purchased it from the accused number 1 in exchange for licenses. Full stop. This purportedly was the information received from an ex-staff of Water DNA Private Limited. Full stop. He therefore contends that there is nothing to implicate the petitioner except a self-serving statement of the complainant. Thus, he contends that the petitioner is entitled to be granted anticipatory bail in the event of his arrest in crime number so and so. He also contends that the offence alleged against the petitioner is neither punishable with death or life imprisonment, and that there is no possibility of the petitioner either tampering the evidence or interfering in the course of investigation, as everything can be gathered from the internet, from the data of the complainant. Full stop. The learned HCGP, however, opposed the petition and contended that the custodial interrogation is necessary to find out whether the petitioner had any access to the data of the petitioner's company and whether he had parted the same to the accused number 1. Parted or allowed the accused number 1 to access those data. Full stop. He thus contends that the petitioner is needed for interrogation. Full stop. I consider submissions the learned counsel for the petitioner and the learned HCGP for the respondent. Next paragraph. A perusal of the information furnished by the complainant to the respondent shows that the petitioner is arraigned as an accused on a suspicion that the petitioner, being a director of a company, could have allowed the data of the complainant's company to be accessed. Data of the company to be shared with the accused number 1. Full stop. If there was anything of that sort, the same can be identified through internet tools, and therefore, there is no need for the petitioner to be subjected to custodial interrogation. as rightly contended by learned counsel for the petitioner, comma, there is no question of the petitioner tampering with the evidence which is available. And the offense alleged is not punishable with death or life imprisonment. In that view of the matter, this petition is allowed. The petitioner is granted anticipatory bail, and the respondent is directed to enlarge him on bail in the event of his arrest in crime number 286 of 2025. Yes.
Serial number 3, Sarath Chandra M. Serial number 3.
Sole accused, my lord. Sole accused.
So either subject to he executing a bond for a sum of rupees 50,000. Yes. Yes.
Serial number 3.
Sharash Chandra.
376 and 354 C, my lord.
376 and
354.
Crimes.
No, my lord. Charge sheet is filed. PW1 is examined. PW1 is the victim. She has completely supported the case of the prosecution, my lord. And there is a recovery of 3 grams gold from the.
Who are the are there any eyewitnesses?
Accused. My lord, they have not placed the entire charge sheet on record.
You get instructions.
I have called for the charge sheet. Entire. 15th, today only I'll receive the charge.
List on the learned counsel for the appellant is petitioner is absent. The learned HCGP seeks time to secure the entire charge sheet. Submits that the victim is examined as
PW1.
As PW1 before the trial court.
She has supported.
And that she has supported the prosecution. Full stop. When queried whether there are any eyewitnesses, comma, he submitted that he would secure the charge sheet. Hence list on
15th.
17th April. Serial
Mohammed
number 4.
Faizan.
Mohammed Faizan. The petitioner.
Petitioner is accused number 2 minutes. Offences are 73.
An offense, you know.
My lord, 341, 342, 364A, 395, 201, read with 120B, my lord.
That's only based on co-accused statement. He was arrested and accused minutes.
I would like to make
only based on co-accused statement minutes.
Only based on
co-accused statements.
Co-accused.
Yes,
petitioner is already convicted, my lord.
He is a convict, my lord.
He is convicted and he is in JC, my lord.
In the same case?
No, different case. ಬೇರೆ case ಅಲ್ಲಿ convict ಆಗಿ in JC.
ಯಾರಿಗೆ? Co-accused bail is granted.
ಮೊಬೈಲ್ ರಿಕವರಿ ಆಗಿದೆ. JC ಇಂದ ವಿಡಿಯೋ ಕಾಲ್ ಮಾಡಿ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಮಾತಾಡಿ ಮಾಡಿಸಿದ್ದು ಅಂತ. CW13 is the wife.
There is no recovery at the instance of the petitioner.
So what is the allegation against you? Please read the complaint.
I was in the custody, my lord, at the time of the offense.
So read the what is the allegation against you? What is your name? Nagendra.
Yes, my lord.
ನಿಮ್ಮ ಮೇಲೆ ಏನು allegation?
ನನ್ನ ಮೇಲೆ ಏನು allegation ಇದೆ ಅಂದ್ರೆ, my lord, ಜೈಲಿಂದ ನಾನು CW13 ಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಸಿದೀನಿ ಅಂತ allegation ಇದೆ, my lord. CW13 ಇವ್ರ ಪ್ರಕಾರ, my lord, ನನ್ನ ವೈಫ್ ಅಂತಾರೆ ಸ್ವಾಮಿ. So CW13 ನನ್ನ ವೈಫ್ ಅಲ್ಲ ಸ್ವಾಮಿ. ಅವ್ರ ಕಡೆಯಿಂದ 35,000 ರಿಕವರಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
What is the allegation? Read the complaint.
Complaint is annexure B, my lord, page 70.
ಓದಿ.
Lords, I, Mohammed Shaheen Hamza, residing with my family at Thomas Pallikani, Kasiyad South, Kannur district, Kerala, while I was returning from Chennai to Bangalore at Husur Road, Anepalya, near to a large drainage, a white color Maruti Suzuki Swift with a registration of K17 made us to take a forceful stop by crossing their car against our car. They were shouting at us and they left due to the military man's intervention. Later at Museum Road in front of Oxford Inn Hotel at 11:45 p.m. they crossed our car again and he came and punched on my car. They forced myself and my friend Shaheen Usman to the back seat. They started driving my car and by threatening and slapping both of us by using knives and swords. They forcefully made me transfer an amount of rupees 10 lakh to an account number so and so. All happened within 2 to 3 hours in the car. In that time, they also crashed my car into their, that they took us to a place which was deserted and foresty, where they forced us to make out with each other. They recorded all these and made us to hold a packet full of ganja and say that we were bringing them from Chennai for sale. This was also recorded. After that, they continuously kept us against our will and tortured us by forcing us smoke ganja.
Is it 10,000 or 10 lakhs?
Minutes, 10 lakhs minutes.
10 lakhs?
Yes, minutes.
Oh.
Minutes. He got time. Accused was in JC minutes. He's a convict minutes. From last 10 years, he's in the judicial custody minutes. Moreover minutes, the only allegation that
he's in judicial custody. When did he come out?
No minutes. He was not present minutes. At that point of time, he was not present. He was in JC.
Incident he was in JC only. There is one allegation, my lord, CW13. According to the charge sheet, CW13 is the wife of the present petitioner accused. She has told that she has received 35,000, which was transferred to her account.
Correct, but if he was in JC, how could he participate in a crime?
Participate. Kummak puttan.
Kummak.
JC in the phone in the Matadi video.
Correct. He can't come like.
Yes, that is agreed.
Same set of facts. Accused number 8 was granted bail by this honorable court minutes.
There is a petition filed under section 439 of CRPC, presently 483 of BNSS, to enlarge him on bail in crime number 73 of SC number 960 of 2022 for the offences punishable under section 75, 341, 342, 364A, 395, 201, 120B of IPC. Full stop. The case of the prosecution is that on 23/8/2025, the petitioner along with another accused committed dacoity and snatched and forced the victim to transfer a sum of rupees 10 lakhs and drew a sum of rupees 15,000 from the ATM of the victim. They thereafter took the victim to a deserted place where they were forced to undress and forced to hold a packet full of ganja, and full stop. They were videographed and they were forced to mention that they had brought the ganja from Chennai for sale in Bangalore. Full stop. The victim also claimed that they were held by the accused till 24th August 2021. Full stop. Based on this, a case in crime number so and so 73 of 2021 was registered by the respondent for offences punishable under section 75, 341, 342, 364A, 395, 201 and 120B of IPC. The respondent, after conducting an investigation, filed a charge sheet for the aforesaid offences. The trial court took cognizance and issued process. Full stop. Next para. The petitioner unsuccessfully moved a petition for bail before the district court and is now before this court seeking grant of bail. The learned counsel for the petitioner submitted that the petitioner was convicted in SC number.
SC number.
SC number
10003 of 17. 10003 of 17.
10003 of 2017 and was sentenced to imprisonment life full stop on yavattu
was dated 5/11/18
on 5/11/2018. He submits that the petitioner has been in custody ever since then, and therefore the question of the petitioner committing an offence on 20, on
23/8/21.
23/8/21
21.
does not arise. He also submits that the other accused who was similarly placed was also granted bail on the same ground.
Yes, my lord.
By this court in criminal petition
That's in criminal
258
petition
of
258 of
2022.
22.
Full stop. The learned HCGP, did not dispute the fact that the petitioner was convicted in the Sessions case mentioned above, and he was in custody from the date of his conviction till the date till today, and is in custody till today. Full stop. In view of the above, the complicity of the petitioner in the commission of the offence, is doubtful. Hence, the petitioner is entitled to be enlarged on bail in the instant case. Consequently, this petition is allowed, and the petitioner is ordered to be released on bail in SC number
Number 960 of 22 minutes.
960 of 20.
960 of 22, pending trial before the
CCH 64.
63rd Additional City Civil and Sessions Judge, Bengaluru, subject to the following conditions. Number 1, the petitioner shall execute a personal bond for a sum of rupees 2 lakhs with one local surety for the like sum to the satisfaction of the trial court. The petitioner shall not tamper or influence the prosecution witnesses. He shall appear before the jurisdictional court on all dates of hearing unless he is exempted by the court for any genuine reason. He shall not leave the jurisdiction of the trial court without the permission of the court till the case registered against him is disposed of.
Serial number 5, Girish B. Baldar.
Girish Baldar.
FIR has been challenged and stay has been granted by the summer court.
You not pressing this?
Pressing with liberty to
learned counsel
file
for the
application in the
petitioners
event
filed a
any
memo.
adverse as per memo, my lordship, I seeking
Could you
liberty.
The
In case
petitioner has
any
filed a memo.
adverse order passed in the criminal petition, I may be permitted to
The
remain.
petition filed under section 438 of CRPC seeking anticipatory bail. Yakesali in crime number 116 of 2025 registered by the respondent for offences punishable under section 108 of BNS 2023. It is stated that the petitioner has challenged the registration of FIR in crime number 116 of 2025 before this court in criminal petition 12800 of 2025, and that this court has granted an order of stay on 16/9/2025. Full stop. Therefore, it is submitted that this petition does not survive for consideration, and therefore the petitioner prays that the same may be dismissed as withdrawn, and liberty be reserved to seek renewal of this petition in the event an adverse order is passed in criminal petition 12800 of 2025. In view of the memo, the petition is dismissed. Liberty is reserved to the petitioner to seek renewal of his request made in this petition. Yes.
Much obliged.
List number 1, serial number for admission, serial number 30. List number 1 for admission, serial number 30.
Partition suit is decreed, which was remanded till the first partition suit is decreed. Please, third defendant's appeal, please.
Raghunath.
Please, Lord.
Suit is for partition.
Suit for partition is decreed, filed by the sister. My contention was, my lord, the sister had already exercised her right in filing a FDP in the earlier instance. That came to be dismissed. Subsequently, she filed the suit before the court below. Our contention was 12 years had lapsed, therefore she could not get a right. This is 12 years had lapsed. She could not.
What had lapsed?
12 years, please, my lord,
So?
from the date of decree.
So?
Therefore, she cannot. That was the contention raised. Therefore, she is not entitled for a share. The other contention was.
FDP was filed earlier.
Yes, please. Not in a suit between father and his brothers. Father, myself, my sister, and one more brother were allotted share jointly, please. Sister, after death of mother, files an FDP. FDP was dismissed in the first instance. Subsequently,
Dismissed
she
on
filed
merits.
FDP is dismissed saying that it is barred by time. Please, my lords. That was not challenged. That was not challenged. Subsequently, in the year 2002, she files a suit for partition. The suit for partition was partly decreed. All the defendants and
The e-suit OS 111 bar 1970 was filed by whom?
by father's brother, please, my lord.
Father's brother.
Please, my lord.
Whether this lady was a party in that suit?
Yes, ma'am. She was a party.
What is her share?
Father was allotted, I'm given to understand, 1/3 or so, one property, please, my lord. That is
Father
the
was
suit schedule
allotted-
property. Suit schedule property was allotted to father, myself as third defendant, plaintiff as one of the legal heir of, daughter of the father, and one more brother, please, my lord.
FDP ಹಾಕಿದ್ಯಾರು?
Sister, that is the plaintiff.
FDP was filed by the plaintiff.
Plaintiff, yes, please. She files FDP in the year 1994. Suit compromise decree of 111 of 1970 was brought into final decree in the year 1994. The court below dismisses her FDP. She
On
files
what ground?
on the ground that it is time bound. And if at all she has this right, she can file a suit appropriately. Not subsequently in the year 2002, she files the suit. Suit was partly decreed. That judgment and decree was challenged by all the parties before this honorable court in RFA 131 of 13. Now, this honorable court remanded back the matter to the trial court for fresh consideration. After consideration, my lord, one
But
change
the suit was filed in respect of the property that was allotted in OS number
111 of 1970.
Was a specific property allotted?
Yes.
The file decree ಮಾಡೋ ಅವಶ್ಯಕತೆ ಏನಿದೆ?
ಮಾಡಕ ಅವಶ್ಯಕತೆ ಇರ್ಲಿಲ್ಲ, but ಅವರು ಹಾಕಿದ್ರು. Absolutely. My lord is right. They could have just entered. Subsequently, suit is filed. I took up a contention that since FDP is dismissed, you are not entitled for a share. That was one of the defense taken. Second defense was, my lord, my father married for the second time, the fifth defendant, my lord. And through the fifth defendant, sixth defendant. This was also challenged by me. Lord, the trial court now, after the remand of this honorable court, comes to a conclusion. In the meantime, my lord, second defendant releases his share in my favor. That is accepted by the trial court because there was no dispute as far as that is concerned. That release of second defendant in favor of third defendant, my lord. Lord, trial court decrees the suit, holding that plaintiff is entitled to 1/6 share. Myself and second defendant, fourth defendant, and sixth defendant are entitled to 1/6 share each. Now, the point which I am urging before my lord is plaintiff is not entitled for a share, was urged by me, is not properly considered by the trial court. Secondly, my lord, fourth defendant is entitled to a share. Sixth defendant could not get a share because the marriage itself was disputed by us. The court below has not properly considered. However, the gift deed to the extent of 1/6 is accepted by the trial court, and once Mr. Natraj, J. Natraj is allotted 1/6 share.
But isn't FDP ಆಗೋಗಿದೆ ಇಲ್ಲಿ?
FDP, my lord, I filed this appeal in the year 2024 itself. Lot of office objections were raised. By the time I could comply all the office objections, and I informed the trial court that appeal is already been pending. The trial court appoints a commissioner. Commissioner gives a report. He also gives a sketch.
Challenge the FDP.
I have challenged that also in this.
No, but whatever is done is correct.
I make one submission, my lords. In fact, the appellant has also participated in that. I appear for respondent number 3 and 4 in this matter. They have also filed their objections to the commissioner application. They have participated in the entire proceedings. There was a sketch. According to them, allocation has also happened. At the time of registration, since the sub-register has demanded all the parties' signature, they are not coming forward. That's the only thing. Since 2024, they have not.
Property cannot be divisible, or an option should be given to the parties to at least.
No, if it is not divisible, the commissioner should say so.
Commissioner gives a sketch dividing into 4 portions.
Building adu eno.
It's an immovable, residential property. There is a structure in existence. I'm in possession of that property.
The FDP challenge ಮಾಡಿ, but so far as preliminary decree is concerned, I don't think there's any.
But even FDP is a challenge now in this appeal.
FDP ನ challenge ಮಾಡಿದ್ರು.
ಮಾಡಿದ್ದೀನಿ.
ಒಂದೇ appeal ಅಲ್ಲಿ ಎರಡು ಹೆಂಗ್ ಮಾಡ್ತೀರಿ?
I
24 ಅಲ್ಲಿ ಹಾಕಿರೋದು ಇದು.
I kindly see the in page 10, my third prayer, please, my lord. Set aside the orders passed by so and so in FDP, 25,024 of 24 by accepting the court commissioner's report and directing the office to draw final decree.
Yes, see. What is the suit property?
Suit property is a residential property measuring 62 feet by 35 feet, please.
62 by
35.
Together with the building thereon. 1,800 square feet or 1,900.
Please, ma'am. Building is still in existence.
1/6 ಹೆಂಗ್ ಡಿವೈಡ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಇದು?
One share was released by notes. One of the brother that was released in favor of them. By virtue of that, he is entitled for 2 shares.
Correct. You are entitled for 1/6.
Please, my lords, I am entitled.
So how can you divide this 1/6 share, 1,800 square feet only?
In fact, my lords, there is a sketch which was drawn.
No, is it feasible to divide? If there's a building.
I have a copy, my lords. I'll just. This has been.
Totally is good.
There were 3 diagrams which was proposed by the commissioner, and this was been.
Correct, you mark lines.
Please, my lords.
But how do you divide? Is it possible to divide? The building has to be pulled down.
They have decided to demolish the entire thing, and they need to. That is what, my lords. In fact, he is also participated at the time of commissioner report also. FTP close agida. There is nothing which has been. There is active participation by the appellant in all the ends, my lords.
No. I had filed objection saying that.
Application only tells that I have filed an RFA, nothing more than that, my lords. Registered also.
Decree is already registered. And it is closed. Decree is not registered. Sub-registrar has raised objection on our health.
I was informed by Prabhakar.
Decree is drawn, my lord. It is not registered. FDP is closed. Lord, I am in possession of the property. I am in possession of the entire property.
ಮುಂದೆ front portion ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ? Part 6. Part 6 is given to whom?
Lord, if my lord sees in page 62.
Part 6 ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
Part 6, my lord, part. But this is how the court says. Part 6 is given to
the plaintiff.
Part 6 is to the plaintiff.
Number 1.
Plaintiff.
You are Jai Kumar.
Yes, my lord. I'm D3.
4 and
I
5.
also get D2 share, please, my lord.
D2 share you will get.
Yes, please, my lord.
After the plaintiff share first next 2, my lords. That is part 4 and part 5 is allotted to the appellant.
Yes, correct ಮಾಡಿದ್ದಾರೆ.
If I'm entitled to 2/3 share, my lord, first option should be given to me because I get a major share in the property.
Yeah, first option ಕೊಡಬೇಕು ಅಂತ.
ಕೊಟ್ಟಿಲ್ಲ.
ಆಯ್ತು, ಮೇನ್ ರೋಡ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಸ್ವಲ್ಪ ರಿಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. Main road value will be more. The property facing the main road will be valued at.
Please, my lords, the property facing main road is given to them. The second, immediately after the.
No, how can the plaintiff get an equal share is what I am asking you.
That finding is also recorded by the court below, my lords.
Property facing the main road. Property facing the main road will have a better value. So value will have to be taken into account. You can't just mark lines on the property and say that everybody gets equally. Value also has to be looked into.
Please.
Yaar plaintiff kya?
Prabhakar is not in station.
Yeah. That final decree, I think we have to be stayed then.
The lordship may have it next week so that they amicably.
Even look at order 21 rule, ಎಷ್ಟದು? Final decree, value ನೋಡಬೇಕು ಅಂತ ಇದೆಯಲ್ಲ ಯಾವುದು?
Order 20, please.
Order 20 is judgment, mister. Order
The
20.
final decree will come on. ನಿಮಿಷ
20 rule 18 ಅಲ್ಲಿ ಇರ್ಬೇಕು ನೋಡಿ.
ಅದೇ
Even the value has to be taken into account.
ಸರ್ ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್ ಅಲ್ಲ ಸರ್ 18 ಬರುತ್ತೆ. Decree in suit for partition of property or separate possession of share therein. Where a court passes a decree for partition of property or for separate possession of a share therein, if and insofar as the decree relates to an estate assessed to the payment of revenue to the government, the decree shall declare the rights of several parties interested in the property, but shall direct such partition or separation to be made by the collector or any gazetted subordinate of collector deputed by him in this behalf in accordance with such determination and under provisions of 54. If and insofar as such decree relates to other immovable property or to movable property, the court may, if partition or separation cannot be conveniently made without further inquiry, pass a preliminary decree declaring the rights of several parties interested in the party and giving such further directions as may be required.
So value also has to be taken into account.
Fact, my lords, one submission off the record, my lords, since the plaintiff, that's the lady, the respondent number 1 in this, she is a very old, my lord, she is unable to walk, and it was through, only considering her age and her factor,
Yeah, that is right. Then how is she entitled to an equal share?
Please.
When she is getting a property facing the main road,
Please.
And the others are getting property, the hind portion of the property.
My share is towards the last, my lord.
Anyway, plaintiff has to answer. Yavattu?
Next week.
Run counsel for the respondent number 1 seeks time list on
20th.
ಯಾವತ್ತು ಬೇಕು ಅದು ಕೊಡ್ರಿ.
23rd.
ಜಗದೀಶ್.
Till then, let them not precipitate, please.
There's nothing to precipitate. ಎಲ್ಲಾನು
ಅಲ್ಲ EPL FDP is closed.
ಅಲ್ಲ but
In accordance to the sketch.
Don't file any EP.
No, my lords,
No EP.
we are waiting for his presence towards the signature.
He says that he is living in that property.
Yes.
Please, my lords, we are not
Don't
disturbed the
dispose
possession, nothing, my lords.
Till the next date of hearing, the operation and execution of the final decree in the FDP number so and so, passed by so and so is stayed. List on 23rd. Is Jagdisha KG?
Jagdisha KG.
I appear for the appearance in this matter, my lords. As on the last occasion, an opportunity was granted in order to settle the matter, my lords. Back then, I didn't have instructions from my client, my lords. Now I have, they are told they are ready and willing to settle the matter, my lords. They'll be posted for mediation, my lords. There's a short inconvenience with respect to the amount, my lords.
What is the offer?
It's coming up to 15.5.
No, my lords. That's a wrong submission, memo of calculation.
He says that you made an offer. Have you made an offer?
Yes, my lords.
How much?
We have told to settle to 10, my lords.
10
lakhs, yes, my lords. My lords, that is the reason. So,
That's what I gave my offer. He said 11.
13 wasn't the offer, my lords. 12 was the offer. So, 12 and Andhru. My client wants to speak directly to the opponents in person. So let it be
tomorrow.
Mediation. 2 weeks time. Is traveling or Mr. The appellant himself is no more, my lords.
Deposited 7 lakhs.
The person Habib is no more, my lords. Now it is the burden. It's upon the son to give all the amount, my lords. That is the reason, my lords.
No, either you deposit 7 lakhs. Since there is a decree for recovery of some of 7 lakhs, which is questioned in this appeal. The order dated so and so, staying the execution is modified and 50% deposit ಮಾಡಿದಿರಾ?
ಇಲ್ಲ ಮಲಸ್ ಅದು ಸೆಟಲ್ ಮಾಡ್ತೀವಿ ಅಂತಾನೆ ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಪರ್ಚುನಿಟಿ ವಾಸ್ ಗ್ರಾಂಟೆಡ್ ಅದಕ್ಕೆ ಲಾಸ್ಟ್ ಟೈಮ್
since the order
ಮಲಸ್ on 2 weeks time ಕೊಡ್ರಿ as a last and final chance
27/3/2026 is not complete, it is open for the respondent to execute the impugned judgment and decree.
Okay, Melas, 1 week may be granted, Melas. Please, Melas. My humbly request on.
ಬರ್ತಾರೆ ಬಿಡಿ ಮನೆ ಹತ್ರ ಬಂದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋತೀವಿ.
Melas will settle the matter, Melas. Will settle, Melas. Please, Melas.
Make a statement that you'll settle it by next week. I'll grant.
Yes, Melas. Next week, yes.
Yavut?
I mean, it's
17th, 16th.
17th.
List on 17th. Learn counsel for the appellant seeks time for settling the dispute. List on 17th as the last chance.
Much obliged.
Serial number 32, Ravi Shankar S.
Yes, Ravi Shankar.
It's kindly pass over.
ಏನಪ್ಪ suit ಏನಕ್ಕೆ? Suit is filed for what?
Suit for possession, my lords.
Suit for possession. Based on title or what? Ejectment suit.
Sorry, my lords. ನಾನು ಫೈಲ್ ಓದ್ಲಿಲ್ಲ ಬೇಕು ನಾನು ಪಾಸ್ ಓವರ್ ನಾನೇ ಮಾಡ್ತೀನಿ my lords.
ಫೈಲ್ ಓದ್ದರೆ ಬಂದಿದ್ಯಾ?
ಪ್ಲೀಸ್ my lords. ಸೀನಿಯರ್ ಇದ್ದಾರೆ 13 ನಲ್ಲಿ ನಾನು ಊರಲ್ಲಿ ಇದ್ದೆ, ಸ್ವಲ್ಪ ನಮ್ಮ ಬ್ರದರ್ ಎಕ್ಸ್ಪೈರ್ ಆಗೋಗಿದ್ರು, ನಾನು ಬೆಳಿಗ್ಗೆ ಬಂದೆ ಊರಿಂದ. ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನಾನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ my lords. ಸೀನಿಯರ್ 13 ನಲ್ಲಿ
ಬ್ರದರ್ ಎಕ್ಸ್ಪೈರ್ ಯಾಕೆ ಬರಕ್ ಹೋದ ಊರಿಂದ?
ನಾನು 1 ವೀಕ್ ಆಗಿತ್ತು ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ, ಅವರು ಹೆಡ್ ಇಂಜುರಿ ಆಗಿದ್ರು. Unfortunately, ತಿರುಗ್ಬಿಟ್ರು my lords. ಆಪರೇಷನ್ ಆಗಿ.
Suit is dismissed.
Please my lords. IA ಇದೆ.
To emergent notice to the respondent.
IA ಇದೆ my lords.
Notice over ಬರ್ಲಿ.
Please.
Serial number 33.
To open for the appellant to serve the learned counsel. Mr. Ravi Shankar. It is open for the learned counsel for the appellant to serve the learned counsel who represented the respondents before the trial court. Yes, next.
33.
Trial court lawyer go serve ಮಾಡಿ.
Ashwin Kumar.
Here for the appellant in this case. My lord, plaintiff's appeal, my lord. Suit for injunction has been dismissed, my lord. As against which, my lord, this present appeal is filed. Suit scheduled property is a property, my lord, which is measuring about 16,447 square feet. The trial court dismisses the
suit is based on title or what?
Title, my lord. I am in possession of the property since year 1942. My lord, my grandfather Surappa purchased the property, my lord, from the original owner, who in turn had purchased it in the year 1942 under a court auction. I purchased the property in the year 1943. Ever since then, my lord, the plaintiff's father Narayanappa was in possession of the property. On the death of Narayanappa, my lord, in a partition which took place in 2011, a certain portion was given to the second plaintiff. The remaining portion is still intact, my lord. There are some old houses, my lord, which are there.
Who are the defendants?
Defendants, my lord, are the neighbors, my lord, who they are residing there.
Neighbors?
Howdo. They are interfere ಮಾಡಿದಾಗ I filed this suit. It's an extent measuring 16,447 square feet.
There is no such property, my lord. There is no such property. That is my contention. They are not neighbors. There is no property. Whatever property he has purchased his grandfather. In that, there was a partition in 1951. In that, 20 to 76 feet has been allotted to the share of his grandfather. That has been sold by his father in 1976 to one Kamalamma. That is the one more shareholder's daughter.
Right. Admit call for records.
It's a second round litigation. Earlier they filed a suit for suit that came to be dismissed.
Admit call for records. Yes.
Sought for injunction ಕೇಳಿದ್ರೆ stay.
ಏನು injunction? Suit is dismissed. ಏನು injunction ಕೊಡ್ತಿದ್ರು?
Trial court, of course, trial court also.
Yeshu Baba.
Serial number 34, Yeshu Baba or Misra.
Lord, suit for partition.
Decreed or dismissed?
Dismissed, my lord. Earlier it was decreed. There was a remand. Then, my lord, it has been dismissed. Upholding a will set up by the defendants, the respondents before, my lord.
Issue emergent notice regarding rule until the next date of hearing, the respondents are restrained from alienating, encumbering or transferring or parting with possession of the suit scheduled property. Yes.
Grateful.
Serial number 35.
Dharanishwaran
K.
Anand Sholapur Mat. Trial court counsel awaited.
Trial court records. It's a short point. It's a recovery.
Last time we had called for records. List after record of the TCR.
Till such time stay maybe.
Interim order granted is extended to the next.
Serial number 36.
Regarding that employee.
Money recovery. Outside.
Money recovery.
Very short point.
But without seeing the record.
I understand. I understand.
Ilangovan.
36. Ilangovan.
Time ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ admission matters ಅಲ್ಲಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಇಲ್ಲ ಲಾಸ್ಟ್ ಬುಕ್ ಪೇಪರ್ ಬುಕ್ ಆರ್ಡರ್ ಆಗಿತ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಡೈರೆಕ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಅದು ಕ್ಲೋಸ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ನಾನು ಇನ್ನೂ ಪ್ರಿಪೇರ್ ಆಗಿಲ್ಲ. ಮೀನ್ ವೈಲ್ ದಿ ಪಾರ್ಟಿ ಆಲ್ಸೋ ಆಸ್ಕಿಂಗ್ NOC.
You can wait, no?
Party also interested to engage in the another advocate council, so dispute is there. So one time, please. Next date,
Suit is dismissed or decreed?
dismissed.
Dismissed.
Yes. Suit, lower court dismissed. One suit dismissed, one suit decreed.
Your suit for eviction is decreed.
The injunction suit is dismissed. Yes, one
you're-
document already produced at the time of the filing the suit. And after that, the conclusion, the evidence, the honorable court directed to produce the original document. So I will,
What is your case? You're starting from the middle. ஆஞ்சநேய வந்தா அங்க போனா இங்க வந்தா இங்க இப்படி
இல்ல,
பண்ணா
இல்ல.
அது அப்படி பண்ணா இப்படி ஆச்சு.
sorry, ಅದಕ್ಕೆ ಅವರು
கேஸ் எப்படி ஸ்டார்ட் ஆயிருந்து அது சொல்லுங்க ஃபர்ஸ்ட்.
the first suit is the injunction suit filed by the plaintiff, appellant. The appellant is the daughter-in-law.
Are you a tenant?
Daughter-in-law, not tenant.
Then what are you?
Daughter-in-law. After the marriage, the construction started. At the time of the construction, the respondent requested to the appellant to help of the money and constructed the 2 floors and 1 floor allotted to you. So that purpose, the appellant paid the money, the pledge of the gold ornaments and gold also hand out to the respondent. Thereafter, after completion of the house, hand out to the appellant. Thereafter, they started the quarrel between the matrimonial dispute. Then advice to the appellant to separate the house, appellant and appellant husband. This is the son of the respondent. Separate the house. 1 week they are residing in the separate house, but not settled. The respondent son not visited to the house. Therefore, the appellant came back to the allotted portion of the first floor.
Yes, Mr. Whether this lady is divorced, whether the marriage is dissolved.
There was proceedings going on.
Marriage is successful, but matrimonial disputes are going on before the family court. The property belongs to the mother-in-law. After that, not the husband. She may have grows against the husband for maintenance, domestic violence, any other remedies. But for mother-in-law is a senior citizen, no my lordship, she has constructed this property out of her hard-earned money, and her husband is trying to live with her, but the appellant is not allowing them.
When was this lady given in marriage? When was the marriage of this, of your son? 2000? 2018? Is there anything to show that the building was constructed before the marriage?
No, lordship, building was constructed.
When?
There was a building before, but the subsequent building was constructed after the marriage. Her only contention is she has given money.
No, first please answer the court question. You say that your son was had married in 2018. Whether there's anything to show that a building existed before the marriage?
2014 is the marriage.
When was the building constructed?
Commenced during 2017. In their own appeal memo at page 3, paragraph 3.
Forget their case. What is your case?
Those are the facts.
2017 you start.
Further floors of the construction started.
ಫರ್ದರ್ ಫ್ಲೋರ್ ಅಂದ್ರೆ ಕೆಳಗಡೆ ಇರ್ಬೇಕಲ್ವಾ? ಅದ್ ಯಾವಾಗಿತ್ತು? ಅದನ್ನ ಕೇಳ್ತಿರೋದು. Was it there even before the marriage?
Before the marriage.
Before the marriage. Before the marriage, the ground floor was there. Further floors were constructed later. For which she claims she has given money 20 lakh rupees. No material to show 20 lakh rupees. She did not have used evidence to that. The lower court has rightly rejected her defense and ordered eviction.
Is she still living there?
She is still living there.
Then it's a shared household. How can you evict her?
Well, lordship, she does not have a claim in mother-in-law's property. That's the eviction suit. That she does not have.
But that is a shared household of the plaintiff.
Even they started residing in a separate property.
Illi.
Adondu rental ತಗೊಂಡು ಅಲ್ಲಿ
So they vacated this place.
It's there everywhere, your lordship.
Even
there. Mother-in-law's property.
That is could be. You allowed your daughter-in-law to stay with you.
We have not. She has entered it illegally. entered it illegally.
Have you said
This
so?
suit is also dismissed.
Have you said so that she has entered illegally
Yes, Your Lord.
in your suit?
Yes, I have said so.
ಎಲ್ಲಿ ಹೇಳಿದೆ ತೋರ್ಸಿ ಕೊಡಿ ಅದು. ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಕೊಡಿ.
Two children have. Two children there.
Where have you said that she has entered illegally?
They have called it out in paragraph 6, page 6 of the appeal.
ಸ್ವಲ್ಪ ನಿಮ್ ಸೂಟ್ ಅಲ್ಲಿ ಹೇಳ್ರಿ.
ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ನಮ್ಮ ಹತ್ರ ಸರಿಯಾಗಿ ಇರಲ್ಲ.
My contenders are called out in the appeal itself.
Trespassed into the B shell property. If she has trespassed, how is the ejectment suit maintainable?
But the trial court is also.
Nodi, please come to the appeal filed against the judgment passed in your suit. Para 4 Odi. In OS number 6994 of 2019.
Para 4 of what?
Para 4 of the judgment passed in OS number 6994.
It's stated that on 13/4/2018. Around 1 p.m., the defendant came near the suit A scheduled property and made a quarrel and demanded to send plaintiff's son along with the defendant number 1. They have also threatened the plaintiff and her husband with the respondents. The Vaisala police came near suit A scheduled property and sent back the defendant. On 13/5/2019, defendants came near suit A scheduled property, broken the main gate lock of the A scheduled property and trespassed into B scheduled property, that is first floor of suit A scheduled property. The plaintiff has questioned the illegal act of the defendants, but the defendants have behaved very rudely and threatened the plaintiff with dire consequences. On 22/5/2019 at 8 a.m., the quarrel was took place between the plaintiff, her husband, and defendants. In that regard, the plaintiff.
So how can you file ejectment suit?
My prayer was for possession, ejectment, and for handing over of the
How?
property.
How can you file a suit for ejectment when you say that she is a trespasser?
Paid court fee also for possession.
I do not know, but your suit is for ejectment. Your suit is for ejectment.
The lower court has called out 13, page 13 of the order of the lower court. Page 17 of the order of the lower court. In 6994 of 2019, Your Honor.
Page 17.
Page 17 of the judgment on 6994 of 2019. It is just and proper to refer the decision reported in 2007-3 SCC 169, wherein the Honorable Apex Court held that the house in question belongs to the mother-in-law of respondent. It does not belong to her husband. Hence, the respondent cannot claim any right to live in that house. There is no such law in India like British Matrimonial Homes Act 1967, and in any case, the rights which may be available under any law can only be as against the husband, not against father-in-law or mother-in-law.
Correct, but you say your own suit says that she is a trespasser. If your suit is on that premise, how is an ejectment suit maintainable? And you are not permitted her to see. It is not permissive possession also. It is not even permissive possession.
It is not their contention. That is not their contention, but the effect of the judgment of the lower court is for her to hand over possession.
Ejectment andre bere, possession bere. Ejectment is different. The consequence is eviction. That's a different thing. Consequence is eviction. But when you file a suit for ejectment, it means that you admit that her possession is lawful, maybe under your permission. Maybe you rented it out. You allowed her to occupy. But once you say she's a trespasser, how can you maintain a suit for ejectment? ನೋಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
If she assures she will leave in some time,
Correct. Mr. She has got now 2 children.
A real fact, my lord.
Proceedings are going
Fair enough. So therefore, you should amicably settle it.
As for residence order or other maintenance,
ಆಯ್ತು ಇಲ್ಲೇ ಹೇಳಿ ಏನೋ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ.
between son and daughter-in-law. I am now trapped in this problem.
Why did you allow another floor to be constructed over your house and allow them to occupy?
Sorry, I will produce the original documents. The trial court rejected the not relevant documents.
Yes, list list for final hearing on date court. Connected matterly, filing of paper books is dispensed. List admit list for final hearing as per seniority. Balakrishna A.
Serial number 37 urgent, serial number 38. 30.
Final hearing ಯಾವತ್ತು ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ ಏನು ಮನೋಹರ್
38 N Manohar.
This matter awaited.
List after service of R2 is BDA.
Also,
BDA ಯಾರು ಅಡ್ವೊಕೇಟ್ ಹೇಳಿ.
earlier trial court Purnima appear ಆಗಿತ್ತು.
ಆಯ್ತು ಇಲ್ಲಿ ಯಾರು ಬೇಕು ನಿಮ್ಗೆ ಅಪೋನೆಂಟ್? You want a weak opponent or a strong opponent? Mr. K. Krishna.
I think it should be there.
Mr. K. Krishna is directed to accept notice for the respondent number 2. Counsel for the appellant is directed to serve a complete set of the appeal memorandum along with all enclosures to Sri K. Krishna. List on ಯಾವತ್ತು?
After a case.
ಏನಾಗಿದೆ? ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
Dismiss.
The second round litigation.
Admit, call for records.
I request my lord, records already there.
Before admission ಮಾಡಕ್ಕಾಗತ್ತೇನ್ರಿ?
Records ಇದೆ.
Yes, admit. List for final hearing on date court.
Records ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
Admission we can't decide, Mr.
Second round litigation my lord.
ನಿಮ್ ಕೇಸ್ ಏನ್ ದೊಡ್ಡ ಇದ್ರದ್ದು ಅದೇನಾದ್ರು?
1963 grant certificate.
Yes,
We are suffering.
Next.
Number
Date
39
may fix.
Lilac Mohammed AB.
This case appear for appellant.
39.
Suit for specific performance filed by the plaintiff.
Adekar.
Yes. This was for the respondent. So the suit has been decreed in my favor.
Suit is decreed.
Yes, my lord.
For specific performance.
Specific performance. The entire sale consideration has been paid.
What is the date of the agreement?
Agreement date, my lord, 16/1/2015.
16/1/2015.
Yes, my lord.
Yes, my lord.
What is the time? Specific?
3 years, my lord.
3 years.
Yes, my lord.
16/1/2013 or 15?
15, sorry. First, the wrong agide, one word. 15. Thereafter, the suit is filed on 14/1/22.
14/1/22.
Yes, my lord. The last shara is, my lord, on 4/7/2015.
Last shara is 4/11/2015.
4/7/2015.
4/7.
Yes, my lord. From the date of last shara, my lord, there is a barred by limitation to file the specific performance suit.
My lord, from 2020, there was lockdown. 2 years.
ಆಯ್ತು 2015 ಇಂದ 3 years ಯಾವಾಗ ಆಗುತ್ತೆ?
18.
2018.
2018.
Within 3 years you have paid this money. Last payment was made on 4/7/15.
15.
So within the time prescribed you have made the payment. So therefore time will start from 16/1/15 only.
No, time limit starts from 16/1/2018, Lord.
Hinge?
Your Honor, may kindly produce para number 24 of the judgment.
ಆಯ್ತಪ್ಪ 16/1/2018
My suit is filed on 17/1/2022.
16/1/2018 ಇಂದ ಶುರು ಆಗುತ್ತೆ ಟೈಮ್. Within 3 years. So 21. COVID-19 ಅಂತ
24
ಹೇಳ್ತೀವಿ.
filed suit on 16/1/2021.
What
But
were
there was
you
a lockdown from 20.
What were you doing from 2018 till 2020?
Below the records, we were promised that the records would be changed, revenue records, which the defendant had no intention of changing the records. He had kept on promising.
Did it prevent you from filing a suit? Did it prevent you from filing a suit? From 2018 till 2020 February to 25,
22.
you could have filed a suit.
Yes, but we had a mutual trust that it will be filed. There was a mutual trust that he was postponing things so that he'll.
No, that is not a justification.
There is no any
See,
shara.
time cannot be arrested just because you believed him, you had faith in him, he conducted himself good with you. That is not a justification to extend the time. Time cannot get extended. Time can get extended only when both of you decide mutually to extend it.
Yes.
2018 ಅಲ್ಲಿ ಮುಗಿದೋಯ್ತು 3 ವರ್ಷ. ಸೊ ಇನ್ 3 ವರ್ಷದಲ್ಲಿ ಫೈಲ್ ಮಾಡಬೇಕಾಗಿತ್ತು. You have filed the suit in 2022, fair enough. It is well within limitation, that's not the issue. Question is, from 2018 till 2020, what prevented you from filing a suit?
Well, I'll take instructions. We may be in date.
So therefore, let the execution of the
27th.
decree be stayed.
Already stays granted.
Stay ಆಗಿದೆಯಾ?
Stay.
All
Well, they're trying to change the structure.
admit
Date may be given, my lord.
list for final hearing. Paper books, so
File, submit it. 27th.
Now
how many exhibits are there?
There are around.
Filing of paper books is dispensed.
Yes.
List for final hearing as per seniority. Interim order.
Right, date may be given, my lord.
The next day.
27. They're trying to change that. They're trying to alter the structure.
What structure?
They're trying to demolish the, cut off the trees.
Structure
Nothing,
or trees or
nothing.
trees?
Alla,
trees.
possession ಕೊಟ್ಟಿಲ್ಲ. How can they are
Till the
asking?
Till the
Any date
disposal-
may be given, lord.
Till the disposal of this appeal, neither the appellant nor the respondent shall cut or remove any standing trees in the suitable property.
They are not, we are not given any possession.
Don't cut, don't remove. Madam, whatever is sold
Please,
with.
I've got photos, my lord.
We are in possession.
Yes, next.
Serial number 40, Mutturaju A.
Mutturaj.
Applying for the appellant, my lord.
Huh?
Applying for the appellant, my lord.
Ah.
Money recovery suit, my lord.
Ah.
It has been declared, my lord.
Ah.
I'm the defendant in that case, my lord.
Ah.
My lord, the plaintiffs filed a case against me.
Typist.
Case, my lord, is a suit against me, my lord.
Ah.
Is a recovery of 7 lakhs, my lordship, which is not borne by, borrowed by me, my lord. My lordship had received the amount from the husband of the plaintiff, my lordship, is with Dr. Balakrishna. Had repaid thoroughly, and it has been exhibited also, my lordship, in the bank statement also I produced, my lordship. Without observing that, my lordship, that the court has decreed the amount of 7 lakhs rupees, my lordship.
Where is the bank statement?
Bank statements, my lordship. In suit number, I connected one more suit as I filed, my lordship. It's a 2336 suit, my lordship. In that, enter had exhibited there, my lordship.
My
Bank-
dear friend, this is a suit for recovery.
Yes, my lordship.
You are the defendant.
Yes, my lordship.
You claim that you had paid some money
Yes, my
to the husband of the plaintiff.
Yes, my lordship.
And that the same is evidenced or reflected in a bank account.
Yes, my lordship.
Where is the bank account?
Yes, it's my lordship.
Have you produced it in this suit?
Yes, yes, my lordship.
Illi.
It's exhibit, my lordship.
ಓದಿ ಯಾವುದು?
1 second, my lordship.
Take 10
ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ಎಕ್ಸಿಬಿಟ್ D7 ಅಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ಟೋಟಲ್ ಎಲ್ಲಾನು ನಾನು ಅದರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ. ಎಕ್ಸಿಬಿಟ್ 6, 7, 8 ಇದರಲ್ಲಿ ಪೂರ್ತಿ ಫೈಲ್ ಮಾಡಿದ್ದೆ. ಪ್ಲೈಂಟು ಅದ್ರ ಜೊತೆಗೆ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ ಅದರದೆಲ್ಲಾನು. ಬಟ್ ವೆನ್ ದೇ ಆರ್ ಮಾರ್ಕಿಂಗ್ ಪ್ಲೈಂಟು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾತ್ರ ಮಾರ್ಕ್ ಆಗಿದೆ.
ಸೂಟ್ ಅಲ್ಲಿ
ಹೌದು ಸ್ವಾಮಿ.
OS ನಂಬರ್ 4499/21 ಬ್ಯಾಂಕ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ನ ಹಾಕಿದಿರಾ ಹಾಕಿಲ್ವಾ?
ನಾನು ಸಪರೇಟ್ ಆಗಿ ಹಾಕ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಸೂಟ್ ಏನಿತ್ತು 2936 ಅಲ್ಲಿ ಹಾಕಿದ್ನ ಇದರಲ್ಲಿ ಕಾಪಿ ಆಫ್ ಹಾಕ್ದೆ. ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸ್ವಲ್ಪ ಇದಾಯ್ತು ಸ್ವಾಮಿ. ಐ ವಿಲ್ ಫೈಲ್ ದ ಫರ್ದರ್ 40 ಇದು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ. ನಾನು ಫರ್ದರ್ I had paid entirely, my lordship. Insofar that amount has been
ಡೆಪಾಸಿಟ್ 50%. ಬರ್ಕೊಳ್ಳಿ.
my lordship, kindly stay grant, my lordship. I will file the application. my lordship.
Deposit 50%. Barkoli issue emergent notice to the respondent. Interim stay of the impugned judgment and decree subject to the appellant depositing 50% of the suit of the decretal amount before the trial court within a period of.
My lordship, I have in a
4
trouble. I
weeks.
will file 25% to 30% and deposit martin. So
Yes, next.
maybe time may be granted for that, my lord.
4 weeks.
Serial number 41 and 42 are urgent. Serial number 43, Prakash
Prakash.
Ramech. Prakash Ramech.
Anjan Kumar.
For the appellant, Your Lordship. It's a plaintiff's appeal, Your Lordship. It was suit for injunction. The suit was dismissed, Your Lordship. Plaintiff
is dismissed.
Suit is dismissed, my lord, please.
Then we'll get the records. Call for records. Is there any other defendant?
What?
Only.
Any other defendant? Sole defendant?
Sole defendant.
Sole.
Call for records. Yes.
Serial number 44.
Call for records.
Hari Krishna Pramod.
Lordships, this is the matter concerning the third party leave to appeal regarding the apartment association. We have given them a representation. A reply was received. Unfortunately, I am not aware if they've been placed before your lordships because it's not reflecting in the cause list.
You know.
So an affidavit was filed by me yesterday with respect to the correspondence that was exchanged, and I believe my learned friends have also filed a reply. They filed a memo along with certain documents. There is a board meeting that they have conducted, but unfortunately, that board meeting is not in accordance with the bylaws at all. I just wanted to point out that aspect of it. Because your lordships had specifically directed that let it be conducted in accordance with law. Let the representation be conducted. The provision clearly says 3 days notice has to be given. They've conducted it on the following day of my representation. That is not 3 days notice.
What else? Why don't you speak a bit loud or you use the mic? Switch on the mic.
The proposal was considered, my lord, and while considering the proposal, it is seen that it is going to affect a majority of the apartment owners. More than 457 apartment owners will affect if that proposal is accepted. So we considered to reject that proposal. That is given yesterday. I filed that memo, my lord. If that is not there,
yes. Consider the same in accordance with law.
My submission, I have several other submissions, but specifically on their consideration of my representation, the bylaws clearly say that regardless of whatever it is, that 3 days notice has to be given. In fact, one of the appellants is a member of the board of managers. They admit that they have not served him a notice to the meeting. So that itself vitiates the meeting. So in fact,
let us not, the more we give this leeway, I think this is what happens.
I understand, your lordship, that's why.
The matter on merits, I'll decide the matter on merits.
I have no difficulties, your lordship. In fact, let the my suggestion would be that let this question of maintainability be considered along with the merits.
No, it will be considered the threshold.
No difficulty.
You please argue the matter, justify how your appeal is maintainable.
Please. In fact, there are several provisions in the Apartment Ownership Act itself which enable an individual member to approach to address their grievances. I will point out those provisions.
my lord, last occasion I served one citation to the other side.
So it is good. You're ready?
I'm ready.
You're ready?
Yes, madam.
Can I take it up? Here.
Specifically on the merits of on the maintainability itself, your lordships, there are several judgments that can be relied upon. But first, I would like to take your lordships through only the Apartment Ownership Act because that is the crux of the entire dispute today. Kindly have the act itself.
Yes, please.
Lordships, today the dispute before your lordships is that there was a resolution by a majority passed by the association. The association has been added as respondent number 2. That decision was challenged by an individual member before the trial court, saying that this decision is not in accordance with law and therefore has to be set aside. That was the crux of his case before the trial court. Initially, the apartment association filed a written statement. It contested the matter to a certain point of time, after which, due to whatever reason, I am not even attributing anything as of now, but no evidence was led by the association or anybody representing the association. In fact, the board of managers was also arrayed as a party. Nobody has led any evidence on behalf of the defendants arrayed in that suit. By virtue of nobody leading any evidence, the plaintiff suit was decreed in favor of the plaintiff. By the decree, what has happened is a majority decision that has been passed by the consent of all the members of the association has been set aside at the behest of one member of the association. That is the crux of the facts. Now, your lordships may look at section 10 of the Apartment Ownership Act. That's the I will slightly touch upon the merits just to give the context as to why I am before this lordship, before your lordships as well. Section 10 says common profits and expenses. The common profits of the property shall be distributed among, and the common expenses shall be charged to the apartment owners according to the percentage of the undivided interest in the common areas and facilities, which essentially means that whatever is my share and my proportionate share in the premises, which is linked to the size of my apartment, that would be my contribution towards the maintenance of the association.
Yes.
That is the basis on which the majority resolution was also passed.
Yes.
Today, what the trial court has decided is the trial court comes to the conclusion that there are a variety of facilities and amenities that are available in this premises. There is no discrepancy in terms of how much a 1 BHK owner would use it or a 3 BHK owner would use it. Therefore, the expenses have to be borne on the number of flats. So if there are 660 apartments, regardless of the size of the flat, the total maintenance expense would have to be divided by 660 is what the trial court has decreed in their favor. That is absolutely contrary to the provisions of this act.
Yes.
This aspect was contested by the association in its written statement. Thereafter, for reasons best known to them, they did not contest it. Parallelly, in fact, what has happened is there was another suit that was filed by another resident on the same cause of action, on the same issue. There were two suits that were parallelly running. In fact, my learned friend was appearing for that plaintiff as well. That suit was dismissed by another trial court. They were pending in two different court halls. One suit got dismissed first. Subsequently, this suit has gotten decreed. The dismissal has not been brought to the attention of this court.
Yes.
Now, as it stands today, if I were to appear for the association or anybody were to speak on behalf of the association has taken a stand before the trial court. The stand is that whatever amendment or whatever resolution has been passed by the association in its general body is a decision that has been passed in accordance with the Apartment Ownership Act, specifically Section 10. If that is the contention of the association before the trial court, logically, if there is a decision that is passed against it, it is up to the association to decide, as an association, as a general body, to decide whether they want to abide by the decision of the trial court or not. It is their prerogative. I understand I am a minority in the association. I am bound by the decisions of the majority. But the difficulty that arises today is the decision was passed in the month of November. The judgment was circulated to the members on the 6th of January of this year. On the 18th of January, the new board of managers takes charge. They table the resolution to amend the maintenance model without even bringing up the question of whether this decision has to be appealed or not. Today, Your Lordship, there are two concepts. One is the board of managers, who is the representative body of the association. The association or the general body is the larger association. Now, if there is a decision that has to be taken which impacts every single person in the association, either adversely or positively, it has to be a decision which has been passed by the majority in the general body meeting. It cannot be left to 8 individuals, or in fact 6 individuals, to decide the fate of 660 people. The scheme of the Apartment Ownership Act, as well as my bylaws, dictate that the board of managers, with the secretary and the president, who will decide the agenda for any meeting. They are in charge of the meeting, they are chairing the meeting, they determine what happens in any given meeting at that point of time. 18th of January, there is a general body meeting that is conducted. There is no issue put to vote at all. The residents are informed that this is the decision, this is the maintenance that will be charged to you. There is no question that is put to the residents as to whether there is a challenge, can this be appealed, should this be appealed, if at all.
So what does the bylaws of the association say? Suppose if any member has any grievance,
please,
can he, by for example, 1/3 number of members, can they join to give a representation asking the association to convene a special general body meeting?
It says majority of the residents.
No. How to convene meetings? For example,
to convene a meeting, it says majority. So the bylaws as it stands today says that if if the residents seek, or if the owners seek to call for a meeting, majority of the residents, which is 331 to meet the majority threshold, 331 people will have to give a representation to the board of managers, and thereafter, based on the representation that is given, the board of managers will have to call for a general body meeting, is what it says. I am not on that. I am simply on the fact that there was an actual meeting that was held for the general body. In that general body meeting, had there been a resolution with a voting percentage been passed, where a majority of the members had decided, no, we do not want to challenge this trial court's decision, I would be bound by it. I would not be before your lordships. My challenge today stems from the fact that it was only an intimation that was given to the residents.
Yes.
Intimation with respect to the maintenance charges. It was not a discussion. There was a calculation, there was a table that was provided. They said 7,400 per apartment would be charged to each apartment. They said this is in accordance with the trial court decision, and therefore it is binding on us. I understand it is binding, but there is a process that is available to you. There is a redressal that is available to you as an association.
No, you compel the association to file an appeal. You compel the association to file an appeal because you say that there was an earlier decision of the majority.
Please.
Fixing maintenance charges based on the square feet.
In accordance with section 10, yes.
In accordance with section 10. If there is an adverse order, you compel the association through a suit or whatever mode to file an appeal.
Your Lordships, I understand. Now, this is kindly, with respect to the Act itself, Your Lordships, we kindly come to section 7. There are 3 provisions I would just point out. One is section 7, one is 23, and one is 24. Kindly see section 7. Each compliance with covenants, bylaws, and administrative provisions. Each apartment owner shall comply strictly with the bylaws and with the administrative rules and regulations adopted pursuant thereto, as either of the same may be lawfully amended from time to time, and with covenants, conditions, and restrictions set forth in the declaration or in the deed of his apartment. Failure to comply with any of the same shall be a ground for an action to recover some dues for damages or injunctive relief, or both, maintainable by the manager or board of managers on behalf of the association of apartment owners, or in a proper case by an aggrieved apartment owner.
Yes.
So there is a provision that enables me as an individual owner to address grievances before a court. Now kindly come to section 23.
Yes.
Section 23, the first sentence of section 23 says, without limiting the rights of any apartment owner.
23.
Section 23, action. Clause is titled action. Without limiting the rights of any apartment owner, actions may be brought by the manager or board of managers, in either case in the discretion of the board of managers, on behalf of 2 or more apartment owners as their respective interest may appear in the respect of any cause of action relating to common areas and facilities or more than one apartment. The first part of the provision itself says, without limiting my rights as an individual apartment owner, the board of managers can also represent me. If there is a dispute that arises with respect to 2 or more apartments, or a dispute which arises with respect to the common areas and facilities, yes, you have a reason. Yes, you have a recourse in terms of representative capacity of the board of managers. That does not take away my right as an individual apartment owner to address my grievances before any court. Now kindly come to section 24, which is act to be binding on apartment owners, tenants, etc. This is in fact what your lordships had pointed out as well, saying that if there is a decision that has been passed by the association, that is binding on me. My point today is there is no decision that has been passed.
Yes.
It cannot be a decision by conduct. 660 people cannot take a decision by conduct. If there are 7 people today in the board of managers who are determining what the agenda of the meeting may be, and if your lordships, I will also take your lordships through the provisions of the bylaws as well. The bylaws mandate that any other topic to be discussed in an annual general body meeting has to be with the permission of the chair. Who is the chairperson of the meeting? The president, who is the board of managers member. So today what is happening is 7 people are sitting and deciding the fate of 663 people, if I am to exclude the 7 people. That is not permissible. So kindly look at section 24. Section 24, the second part of section 24 says, all agreements, decisions, and determinations lawfully made by the association of apartment owners, which is to say the general body, in accordance with the voting percentages established, which means that it has to be a decision that has been taken by the general body, and there must have been a voting as per the percentages. Today every apartment gets 1 vote, so 660 votes or whatever, based on the quorum of the general body meeting, there must have been a voting mechanism that should have been adopted in that general body meeting for any decision to be binding on me. So even if it is to assume that the decision of the association is to not file an appeal, my submission would be there is no decision at all. So as far as the conduct of the association is concerned, whether they wish to file an appeal, they do not wish to file an appeal is their prerogative, because they are the elected representatives, and it is my fate that I will have to live by them and die by that decision. But as an individual member, as your lordship saw in section 23, my right is not taken away.
Yes.
Section 23 is very clear to say, without limiting the rights of any apartment owner, the board of managers can also represent my grievance before any court or authority. So insofar as my right with respect to the trial court's decision is concerned, I am directly impacted. I had in fact handed over a decision on the first hearing date. This is the decision of H. Anjanappa, your lordships. I handed it over in the first hearing itself. This is a 2025 decision of the Supreme Court. While this petition pertains to a property dispute, there are specific guidelines laid down with respect to how leave to appeal may be granted. Kindly come to para 43 of the decision, Your Lordships. 43 lays down the principles, and these are general principles. They are not specific to any nature of dispute.
Yes.
Para 43. The principles governing the grant of leave to appeal may be summarized as under. Sections 96 and 100 of the Code of Civil Procedure respectively provide for preferring an appeal from an original decree or decree in appeal respectively. The said provisions do not enumerate the category of persons who can file an appeal. However, it is settled proposition that a stranger cannot be permitted to file an appeal in any proceedings unless he satisfies the court that he falls within the category of an aggrieved person. It is only where a judgment and decree prejudicially affects a person who is not a party to the proceedings, he can prefer an appeal with the leave of the court. I will pause here for a moment, Your Lordships. Today, as a member of the association, there are two concepts. One is the association itself. Two is its members. Any decision that is passed by either the trial court or any court for that matter, with respect to the association, impacts me as a member. It may impact the association as well. But does it impact me as a member? Yes, it does. Because today there is a financial implication that is cast on me contrary to my own bylaws. So therefore, the answer to whether I am an aggrieved person is answered in the affirmative. Moving on.
Please tell me one thing.
Yes, sir.
You are the owner of a larger apartment?
I am the owner of a smaller apartment.
Smaller apartment.
Smaller apartment.
So how is it going to impact you?
Lordships, today what is
in terms of maintenance charges?
Please.
What applies to Tom applies to Harry also. What applies to you applies to the defendants or the other apartments. So every flat owner will pay a fixed amount. It could be less than what you were paying earlier.
Please.
Or it could be slightly more than what you were paying earlier. But everyone in the apartment is going to pay the same amount of money. So how are you going to be affected?
Lordships, I'll explain how I am affected. Today, the maintenance charge that is being paid by every apartment owner, the Act prescribes that it is linked to the undivided proportionate share for the simple reason that if I am the owner of an apartment of say 1,200 square feet and the undivided share with respect to that is 300, I am the undivided owner of 300 square feet. Therefore, my liability with respect to the maintenance of 300 square feet is a metric that is followed.
Yes.
So every apartment association, either most of them don't do it on the basis of the UDS, but the math remains the same.
No, but suppose, for example, you have a smaller UDS.
Please.
But you will be running around all the property, all over the property.
Please.
It is not as if you will be only restricted to your 200 square feet of undivided interest.
Absolutely.
You will be using the entire property. Your car will move around in the entire basement, in the entire parking lot, in the entire ramp. It will be used. Your vehicles will be used on that. Your children will be running around the entire apartment complex. Your children will be using the entire swimming pool. Your children will be using the play area. Everything is used. Just see, undivided interest is only for referring the building to the value, to the land.
Please.
Suppose if the building falls down tomorrow,
please,
what will be your interest?
Absolutely.
Interest is only to undivided interest.
Please.
It is not. It is very symbolic. It is symbolic.
Absolutely.
Then you can't say just because a flat owner has got 300 square or 1,200 square feet of super built area, he has got a higher undivided interest, so therefore he has to pay more. Doesn't appear logical.
But Your Lordship, that is the scheme of the Act.
It might be the scheme for you to be aggrieved if you are asked to pay something more.
Then what is legally permissible?
What is something more than what you were paying earlier? Then you become an aggrieved person.
I am paying more. I am paying more today.
Yes.
Your Lordship, so previously, say for example, my maintenance would be about 3,000 rupees. Today I'm paying 7,400.
Yes.
Because what would necessarily happen is, if I was paying on the basis of, I'll just go back to my example. If I was paying it on the basis of say 300 square feet or 1,200 square feet of undivided share, and the association is levying a fee of say 4 rupees or 5 rupees per square feet, I would be paying 4 rupees into 1,200, which is the 6,000 or 4,800 is what I would be paying. Today, what will happen? And as compared to say somebody who owns a 2,000 square feet apartment, that individual would be paying about 8,000 or 10,000 rupees of maintenance. Today, what has happened is my maintenance has gone up from say 3,000 rupees all the way up to 7,400. My maintenance is doubled.
Yes.
Which collectively, in fact, there are about 200 apartments which are affected on this side. There are about 460 apartments which are on which stand to benefit from this decision as well. I will be candid because today the association by majority is an association which has more number of larger apartments and lesser number of smaller apartments. So there is a significant minority of 200 or so apartments who are 1 BHKs and 2 BHKs who stand to be affected the most. Collectively, cumulatively, the differential amount that they will be paying on this new maintenance model stands at about 50 lakhs per year. So therefore, every person in that 200 would be an aggrieved person. 11 of them are before your lordships. In fact, there is a statement that has been circulated amongst the residents. About 90 other people have supported this as well. So close to, if I were to assume that about 100 people are affected by this, they are all aggrieved persons by virtue of the fact that there is a adverse financial implication that is being cast on all of these people. So my maintenance, which used to stand at rupees 3,000, has doubled and become 7,500. Therefore, I satisfy the requirement of being an aggrieved person. The fifth point in the same judgment, Your Lordship. A person aggrieved to file an appeal must be one whose right is affected by the reason of the judgment and decree sought to be impugned. The decision is the reason that this change has happened, and that is categorically captured and admitted by the association as well. The expression person aggrieved does not include a person who suffers from a psychological or an imaginary injury. That is not the case here, because I am suffering a direct and a consequential injury arising out of the trial court's decision. It would be improper to grant leave to appeal to every person who may in some remote or indirect way be prejudicially affected by the decree or judgment. And finally, ordinarily leave to appeal should be granted to persons who, though not parties to the proceedings, would be bound by the decree or judgment in that proceeding and who would be precluded from attacking its correctness in other proceedings. This is the other relevant provision that would be looked at. As your lordship asked me, why don't you go file another suit? Every time I go file another suit challenging this decision, even if I were to challenge the decision to implement the 7,400, I would be hit by the same decision that is impugned before your lordships. Because as an association, I am bound by the decision that binds the association, and therefore I am bound by the decision as well. Yes. And there is no possible way that I can challenge this decree apart from the first appeal. If I were to approach another trial court, the trial court would say that this decision has attained finality insofar as the association is concerned, and therefore there is no possible way that I can set aside that decree. So both these provisions, I am an aggrieved person, and there is no other recourse that is available to me to impugn these proceedings apart from a first appeal. Therefore, the leave to appeal must be granted, your lordships. And I apologize, just to clarify on the section 10 aspect of it, there is a decision of the Bombay High Court as well. In fact, the challenge that we have faced with the Karnataka Apartment Ownership Act is there is not a single decision on this specific aspect of maintenance till date from our High Court. This is, I mean, possibly the first one. There is one decision of 2025 August of the Bombay High Court, which I had also in fact produced along with a memo of citation. That is on the merits of the matter, but the Bombay High Court also reaffirms this proposition of section 10, which says that if there is common expenses that are sought to be incurred, it would be on the basis of your undivided interest. That is as far as the merits is concerned.
So, my lord, this maintenance charges, my lord.
Whom do you represent?
Association.
You represent the plaintiffs before the trial court?
No, my learned friend appeared for the plaintiff. My other friend appeared for the association.
Yeah, association doesn't have any say here. It is only the plaintiffs who have to answer.
The main thing I would like to bring before your lordship. My learned friend was appearing for the association in the beginning, before. So for the association and the board of management, and when the board just changed, he had his retirement memo. That I think the association has submitted whatever email correspondence was on the last hearing. And
you represent the association earlier.
I was representing the association.
Why do you do this?
Lordships, no. Today, my submission that I would not be in conflict because my stand today is the same stand of the association before the trial court. I did not appear for the plaintiffs.
Whatever it is.
I would understand if there is a conflict.
Correct, but you are now fighting against the association.
I am not. Yes. I am not fighting against the association because today the association is not a contesting party. By their own admission, they say I am not contesting anything. I have accepted the decision. My grouse is only against the plaintiff who is the beneficiary of the decree.
He had at that point of time, he had submitted the written submission, and for the reasons best known to him, he had taken. The main thing is that the maintenance money is paid by all the members on the assumption that the maintenance of the apartment will be carried out. And it's not only the maintenance; it's the usage fees. the usage of the amenities that is equally used by him and by the 11 appellants, and all the others are equally. And the main thing is that, and they have been provided all the irrespective of sizes, all the apartment owners are provided 4 amenities cards for which they can use. And the clubhouse, whatever the clubhouse they're using, and all 4, whether 3-bedroom flat owners or 4-bedroom flat owners or 2-bedroom or 1-bedroom flat owners, they all use the same. And on that proposition, earlier there was a general body meeting where Board of Managers 2 had conducted and decided a maintenance model, which was upturned by the next general body meeting, wherein my learned friend had represented this Board of Managers, who had upturned the entire thing. First, it was the builder who had managed the maintenance model, and it was on the advance paid. When the association took over, they first conducted a meeting to decide on the maintenance charges, and there was a resolution passed based on that it was to be on the flat basis, because the irrespective, there are no services being provided inside the apartment. It's all the common facilities, whether the garbage, the security, whether they are owning 1-bedroom flat, the security is being provided, 2 security is being provided to their blocks, each blocks. So it is actually equal. It is not. That is why the association had decided at that through a general body, they passed a resolution which is being passed as resolution number 9 in the it has been in the civil court.
But
order
how
also.
can your bylaws be against section 10 of
Section 10, it is silent, my lord. If you may see that, it doesn't say about the usage charges. It doesn't say.
I
It says
apologize.
only,
expenses in the.
it says it's only expenses, common expenses for the maintenance.
What do you mean by common?
Maintenance means, suppose the building is there and there is a painting that has been collected as per square feet.
Yes.
This is only for the usage. The maintenance is being collected. It's only for the usage.
Now, what about expenses? Expenses
Expenses
include
is-
everything.
Expenses, it is they are not repainting the maintenance. That has been collected separately,
Whether
because
the
it is not defined in the bylaws what is the expenses.
Yes.
It is only common. Section 10 says only common expenses.
The
That
Act
is common
defines
expenses.
common expenses, your lordships.
See, what is the definition?
Common expenses says insurance, including the insurances.
Common expenses under clause 8G.
What is it?
Section 3(8). It says G. Common expenses means all sums lawfully assessed against the apartment owners by the Association of Apartment Owners.
Other section?
Section 3, your lordships.
Section 3 of common expenses, huh?
Common expenses.
Yes.
All sums lawfully assessed against the apartment owners by the Association of Apartment Owners, expenses of administration, maintenance, repair or replacement of the common areas and facilities, expenses agreed upon as common expenses by the bylaws, and expenses declared as common expenses by the provisions
We
of.
will continue at 2:30.
Please.
Kalburgi, sir.
Matter pertains to Kalburgi bench for being spoken to, serial number 1, Sivakumar Kallur.
This court had imposed cost of rupees 1 lakh
That
payable
amount is,
by
we
the
have,
appellant to the Karnataka State Legal Services Authority. However,
but yes, my lord.
the appellant has deposited the expense of the cost of rupees 1 lakh before
Yes.
the High Court Legal Services Committee, Kalburgi bench.
Yes.
Since the appellant has deposited the cost is ordered before a wrong authority, the same is condoned and is treated as sufficient discharge of the order passed by this court directing imposing cost of rupees 1 lakh payable to the Karnataka State Legal Services Authority. Yes.
One submission, my lord.
Ah,
This amount of 1 lakh can be transferred to the Karnataka, if your lordship.
say we'll use it for some other purpose. We'll say that your lapse is condoned.
Yes, my lord. No, I thought, my lord, once again I have to.
Thank you.
Much obliged.
Thank you.
Suit is for possession, isn't it? Suit is for possession. You come and say that you appear for the appellant, I'll admit it. Can you say that? C number 3. ಯಾವುದು second list. Unconscious for the petitioner has filed a memo to withdraw the petition. The memo is taken on record and the petition is dismissed as withdrawn.
Serial number 44.
Just before my learned friend commences, my only request to her would be to restrict herself on the maintainability and not get into the merits. Because on merits, I have not addressed arguments yet. That's all.
Please use the mic.
Section 10, and they aggrieved. That is the reason I have come to the, my lord, the common expenses is defined under section, under 3G, my lord. It is all sums lawfully assessed against the apartment owners by the Association of Apartment Owners. Expenses, administration, maintenance, repair or replacement of the common areas and facilities. Expenses agreed upon as common expenses as per the bylaw. Expenses declared as common expenses by the provisions of this act or by the declaration or by the bylaws. My lord, 3F says about common areas and facilities unless otherwise provided in the declaration or lawful amendments thereto means the land on which the building is located, the foundations, columns, girders, beams, supports, main walls, roofs, halls, corridors, lobbies, stairs, stairways, fire escapes, and all these which are mentioned till 8, my lord.
Yes.
The common areas, the common amenities and facilities and infrastructure provided is by way of a clubhouse, and also like gym, spa, crush, saloon, multipurpose hall, library, badminton, squash courts, table tennis, billiards, cards room, yoga room, swimming pool, multipurpose play court, children's parks, lawns, jogging track, maintenance and upkeep of the passenger, security, firefighting, swimming pool and water body filtration plants, and all these other amenities which are not defined under the act or which are not defined under the bylaws. And another thing
No, I
is
apologize.
that
They're defined under the act, my lord.
let me complete. The main purpose of this, at my point, is that as one-bedroom flat owners, they were underpaying the maintenance amount till whatever the maintenance usage fees till date. For example, if I am owning a Benz car and I'm using the road, the same when I'm owning a Maruti 800 car, I'm using the same road and I'm paying the same toll fees. It's applicable to the same. The clubhouse is being used by the 4 and amenities cards, specific amenities cards are paying. And if I'm using more than 1, I mean more than 4, I'll have to pay 100 rupees more for the guest charges. This is what the applicable club charges. And for the usage that has been disturbed, when it first started itself, the dispute started. And the association had.
What does the law say? What does the law say?
The law doesn't state about the facilities and amenities provided.
It says common expenses.
Yes, my lord.
Common expenses is defined.
Yes, my lord. Common expenses is defined based upon the common usage and areas and facilities.
So it
where
it says maintenance also. Please read common expenses.
My lord, G2 expenses of administration, maintenance, repair or replacement. This is termed as maintenance, but it's actually usage fees. It's termed as maintenance. They are not using for the whatever is collected is not using for the maintenance of the apartment. That is what my submissions. It is using for the usage fees. Whatever the clubhouse, it is a 5-star facilities, one of the largest apartment.
Please wait.
Yes, ma'am.
If there is a club,
yes,
there is a club usage charges.
Yes, my lord.
There's a.
It is not separated.
No, please wait. Yes. Maintenance is different.
Yes,
no
my
dispute.
lord. Yes.
Club usage charges is different.
Yes, my lord.
No dispute.
Yes, my lord.
But whatever is the maintenance
yes, my
of
lord.
the common areas, common facilities.
Yes, my
common
lord.
facilities.
Yes.
Like a lift.
Yes, my lord.
Like a what you call parking area.
Yes, my lord.
All these are all facilities.
Yes.
Amenities may be different.
Amenities,
Facilities may be different.
Yes, my lord.
Amenities, there might be a separate charge.
Yes, my lord.
For facilities, question would be whether section 10 applies or not.
Section, my lord, this is an act of 1971. There was no amendment to that. At that time, that most of the apartments do not have all these facilities and amenities which has been.
Forget the amenities, facilities.
Facilities, my lord, every apartment doesn't have security.
For example,
Yes, my lord.
there is a garden area.
Yes, my lord.
There is a garden area.
Yes,
Swimming pool, everybody is allowed.
Say everybody is allowed,
Everybody is
irrespective
allowed.
of the flat size.
It's a facility, not an amenity.
Yes, my lord.
It's a facility.
Yes, sir.
Park is a facility.
Facility.
An open amphitheater is a facility.
Yes, my lord.
Not an amenity.
Yes, my lord.
So for maintaining this,
yes,
it will be a common maintenance charge.
Charges, yes, I do agree. Yes.
What he is saying is under section 10.
Yes, my lord.
The expenses should always be in relation to the area
of the flat.
Yes,
my lord.
Whereas by virtue of this judgment,
yes,
it will be a common fee irrespective of the area.
Yes, my lord.
Of the flat.
Yes,
so for example, if you have a 2 BHK, you will pay X amount.
Yes, ma'am.
If it's a 4 BHK, they too will pay X amount.
Yes, ma'am.
This is the consequence is what he is saying.
Yes, ma'am.
Which he says is in violation of section 10.
Yes, ma'am. That is his
case.
Yes, ma'am.
So you just address that.
Yes. So what I'm saying is that common expenses, what that was section 10. Common profits and expenses. The common profits of the property shall be distributed among and all the common expenses shall be charged to the apartment owners according to the percentage of the undivided interest in the common areas and facilities. Wherein I have read the common areas and facilities. In this, it is nowhere provided. That's what my contention is. That it is in this. It is nowhere provided about the infrastructure and the facilities which has been provided as per the other. That is what I am saying. It is not used for the maintaining. Used for maintaining that, it's not for the upkeep and maintaining it is being used. There is no separate charges being used as given to them as common facility. There is no bifurcation of what are the charges being used and has been used and what has been really used. And not only that, my thing is that if whatever it's irrespective of the flat size, they have been, and most of this 1-bedroom flat owners where they have contended that they have been charged higher, it is not only because of the civil court order, my lord. The thing is that the maintenance prices have not been increased for the last 6 years because of the ongoing cases. So suddenly they have decided to increase the maintenance charges, not because at 307,000 suddenly it jumped to 7,400. It is not like that. It is because earlier it was only 41 lakhs was the overall monthly expenses. Now it came to 50 lakhs, where now the association, as per the decree, has decided to charge among all the association members as equally. That is what my contention. And the next part is saying that association has not duly represented the proceedings, wherein I have told that association, he himself has represented the board of managers plus the association. He has filed his written statement. My learned friend has filed the written statement. After he submitted his retirement memo, another association has appointed another advocate and has conducted the proceedings and has cross-examined the plaintiff, and also a written arguments also was filed based on the common expenses and area, and wherein the judge has specifically, after full-fledged trial and after hearing both sides only, has passed this order. And now again he's saying that he is not he's an aggrieved person. I would submit a memo of Supreme Court decision. Rashtriya.
You're also relying upon this judgment.
Yes, ma'am.
He's also relying.
My learned friend is because it's based on the principles on
the 47 page, my lord.
Singal
Lalchand versus Rashtriya Swayam Sevak Sangh. Here the Sangh has been duly the last paragraph at the page number 51, my lord. Thus, it could be held the Sangh have been duly represented in the previous proceedings and conducted the litigation, and on behalf of the Sangh bona fide, and were unsuccessful in the suit, no one on behalf of the Sangh can lay an objection in the execution nor plead nullity of the decree. The doctrine of res judicata prohibited the members of the Sangh to obstruct the execution of the decree. The decree judgment binds every member of the Sangh, and therefore the appellant is entitled to have the decree executed and possession taken. This is where I'm saying that they were duly represented, and even if they were aggrieved by the order, they could have impleaded that time. They sat for 5 years. They knew that their case was against a few people. They will be prejudicially affected. They could have impleaded themselves. And moreover, two of the members, the plaintiff had actually made them as parties to the suit. They themselves had filed a misjoinder application, and the misjoinder application actually was not allowed. Later on, the plaintiff itself had submitted a memo for deletion of the parties of the two members. So now they cannot say come back and say that their rights were not affected. They were not able to present their arguments, because already the association has, on their behalf, board of managers and the association has defended the suit.
Yes.
Yes, ma'am.
Yes. You have anything else to add regarding maintainability of the appeal? Now, you are also relying on the same judgment.
As far as the section 10 is concerned, my lord, that is clearly defined what are common facilities, common amenities.
No, forget that. Come on the locus standi, whether he is an aggrieved party or not.
As far as for the usage of these facilities, there should be a parity in the charges towards.
No, you are going into the merits.
No.
I'm only saying.
No. So
about this locus standi.
So they cannot be claimed that they are a aggrieved party. So usage is the same by all the apartment owners. So payments or charges towards that usage should be the same. That is my contention, and they cannot claim that they are aggrieved. So IA number 1 may kindly be dismissed.
Based on next Thursday, to decide regarding the maintainability of this appeal. Yes, you have anything else to add?
I have 2 points to just 2 points, Your Lordship. Your Lordship was looking at the Act. My learned friend read only clauses 4 and 5. She did not read 7 and 8. Under common expenses, common areas and facilities, it also says such community and commercial facilities as may be provided in the declaration. So everything that she referred to, say a clubhouse, a gym, a sauna, a jogging park, all of that is included in that. 8 is a generic clause which says all other parts of the property necessary or convenient to its existence, maintenance or safety or normally in common use.
That is on merits.
That is on merits. No. Specifically on, I will supplement it on the next date.
No, supplement. I'll decide the maintainability on
then,
the next date.
Just one more point on the maintainability aspect, Your Lordship. Today, what has happened is the plaintiff is one individual who's approached the court. It is only one individual. So what applies up to the goose applies to the gander as well. So if her suit was held to be maintainable and she was given relief, whether regardless of what the merit, without going into the merits of the case, at least as far as maintainability of my appeal, it is maintainable.
You argued this point on the last.
I did.
I gave back to you in the same what you call terminology. What applies to goose applies to the gander. I gave it in a different.
I understand.
Yes. Next.
That is the only thing I wanted to support.
Serial number 45, Ankit is ready. Ankit
is ready.
Here for the appellate, the defendant's appeal in a suit pertaining to declaration and possession. My lord, please come to page number 70 of the appeal memorandum.
Kevatar Devraj. There is no representation for the Kevatar respondent. Since the suit is for declaration of title and for recovery of possession is decreed, it is appropriate that the impugned judgment and decree is stayed. It's already there. It is appropriate that the appeal is admitted. Accordingly, appeal is admitted. Interim stay of the impugned, the operation and execution of the impugned order. Yes. Idike, for this you are asking for adjournments. You made 2 attempts for adjournment.
Counsel whose matter it is
Yes. Baswana came. Filing of paper books is dispensed for the time being.
Till number 46,
Baswana.
Baswana came.
Based on title or possession? Based on past possession.
Shaded is there, we are climbing under the shaded.
So it is based on title. Suit properties.
Property is site 1072 square feet. Thereafter, is portion, two portion has sold in favor of the claim in other case also. Both, the site number 186 bar 1 scheduled is there. Measuring 484 feet. And originally, the property is measured, having one Shazam.
Call
for the title of the property.
Call for records. For records.
That not the trial court has held, it is based on a void decree. Not all these sale deeds were based on a void decree.
Let us see. Call for records.
Model number 40.
Interim order, you know.
They wanted an interim order of
Suit is
stay.
dismissed, Allah. Suit for injunction is dismissed. Was there any interim order during the pendency of the suit?
No, no.
Then
Now, alter is all right. Not now they want to say we are in possession ali. SC/ST organizations ಎಲ್ಲ ಬಂದು ಗಲಾಟೆ ಆಗ್ತಾ ಇದೆ ಜಾಗದಲ್ಲಿ.
Nobody shall do anything there.
Nobody. This is today's issue, Manoj. Wood ಎಲ್ಲ ತಂದು ಎತ್ತಾಕೋ ಪ್ರಯತ್ನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. This is what is happening.
It's a vacant site. You know.
There is no residential property. There is a shed belonging to me where Manoj, I am in possession that has been established. That is my shed not signed. That is what.
No work, nothing. Ella nilsbeku. Illa andre I'll vacate. No work will happen, mister. No work. Yes, work will.
Absolute void decree.
No, you have suffered as decree, so there will be no injunction unless you say that you will not do anything in the property.
The defendant is not claiming the property as the owner. The dispute is the property matter. They are claiming 91D 40 into 105. They are not identifying the suit. They are claiming that based on the gift deed executed by one Shardama as measuring 1 acres and they have not disputed.
My title has been established. Findings are there to that.
They are not given any proper identification.
So what do you want to do? Yeah, no injunction. If you are doing anything in the
minutes now at around 2:15 minutes. 2:15 minutes today. Wood dump ಮಾಡ್ತೀವಿ, machine ತರ್ತೀವಿ. There are some SC/ST organizations which have come to the spot. Today, minute.
Is this the building that exists in the property?
May I just have a look?
This one?
That is not the one. That is not the one. There is a shed. There is a shed.
ಯಾವುದು ಇಷ್ಟು ಫೋಟೋಲ್ ಯಾವ್ದಿದೆ ಹೇಳಿ ಬಿಲ್ಡಿಂಗ್?
ಒಂದು ಶೆಡ್ ಇದೆ ಅಷ್ಟೇನೆ ಅಲ್ಲಿ. ಖಾಲಿ ಸೈಟ್ ಒಂದು ಶೆಡ್ ಇದೆ. ಒಂದು ಖಾಲಿ ಶೆಡ್ ಇದೆ. What I wanted to
ಹೇಳಿ ಯಾರು ಕಮಿಷನರ್?
ಇವ್ರು ಆಗಲ್ಲ.
ಕಮಿಷನರ್. Yes. Anybody? Any lady advocate? Youngster? Yes, will you go? Yes, tell me. 10,000 ಗೆಲ್ಲ ಬರೋದು.
Small carpentry work is going on.
10,000 ಗೆಲ್ಲ ಬರೋದು. If you want a commissioner to go and submit a report, minimum is 25,000 rupees. Minimum. Maximum? Yeah. ನಿಮ್ಗೆ ಬೇಕಾ?
Sorry?
You want a commissioner to be appointed or not?
No, I don't.
ಬೇಡವಾ?
I am concerned now that calls has been levied there. One can take care of it. But if it has to be shared, I will ensure it is.
No. ನೀವು 25, ಅವ್ರು 25.
If it has to be shared, not definitely it will be shared. If it has to be shared.
ಅದೇ 25 ನೀವು 25 ಅವರು.
I really don't want a commissioner, but if he wants it, do not sign. If your lordship say you share it, I can go ahead.
Should cut both sides.
Whatever not, I'll live there. would a specific date be appointed so that
Yes, yes, sir. All those things I'll do. Once you agree on the fees, I'll do everything. But the admit, call for records, paper books, history, annexures, exhibits.
No, but it might be required. There are some around 31 exhibits for the.
Oral evidence history, witnesses. Filing of paper books is dispensed for the time being. No, adal duddolitu. Since it is disputed by the learned counsel for the respondent that learned counsel for the appellant submits that the appellant is in possession in a shed constructed over the suit property. However, the respondent disputes that the appellant is in possession but claims that the shed belongs to the respondent. Full stop. The appellant has placed on record some photographs which is also disputed by the learned counsel for the respondents. Therefore, to find out whether any construction exists on the property or not, Mr. Roshna, so and so, who was present in the court, was requested to visit the property and submit a report as to whether any shed which matches the description of the one mentioned in the photos.
There is one small shed.
ಯಾವ್ದ್ರಿ ಫೋಟೋ ಹೇಳ್ರಿ ನಿಮ್ದು ತೋರಿಸ್ರಿ ಯಾವ್ದು ಫೋಟೋ ಯಾವ್ದೋ ಒಂದು ಪಿಕಪ್ ಮಾಡಿದ್ರು which matches the description of the photo of the shed found in the photograph furnished by the learned counsel for the appellant exists in the suit property or not. Memo kudi. So she agreed to visit the property, and therefore she is appointed as a court commissioner. She shall visit the property and submit a report. Shall visit the property on, when can you go, madam?
And then
Saturday or Sunday.
Saturday.
One reasonable request, not. If they say work, which they say we are carrying out, etc. There is this is what they are saying.
One yav photo kodi ಹೊರಗಡೆಯಿಂದ kodi one photograph.
This is what they are saying.
You shall visit the property on Saturday.
Please.
At what time? 11 o'clock.
Please.
At 11 o'clock. And submit a report. She shall also indicate whether any activity is undertaken in the shed if it exists on the property. Full stop. The commissioner's fee is fixed at a sum of rupees 50,000 payable by the huh? ಮರ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಸ್ಮಾಲ್ ಕಾರ್ಪೆಂಟ್ರಿ ನಾ yes
one thing
payable by both the appellant and the respondent in equal portions at the spot. Full stop. List for report of the commissioner on gadva on the appeal for the report of the commissioner on 17th. 17th. ಏನೋ ಟರ್ನಿಂಗ್ ಎಲ್ಲ ಮಾಡ್ತೀರಾ ನೀವು? ಟರ್ನಿಂಗ್ ಮಾಡ್ತಿದ್ರಲ್ಲ ಇಲ್ಲಿ, ಪ್ಲೇನಿಂಗು ಟರ್ನಿಂಗು ಏನೇನೋ ಮಾಡ್ತಾ ಇದ್ದೀರಾ.
ಈಗ ನಾವು ಇನ್ನೊಂದು ಅರ್ಧ ಗಂಟೆಯಲ್ಲಿ ಬಿಟ್ರೆ ಸ್ವಾಮಿ, this will come into the shed. That is my apprehension. And I can point out the latitudes and longitudes also.
List on 17th. Yes, next. Karir ಬೇಗ Mr. MD Raghunath. ಕೊಡಿ ಲಿಸ್ಟ್ along with RFA. 46 ಅದೇನಾ? ಬಟ್ ಇವಾಗ ಎರಡು ನೋಡ್ಬೇಕಾ ಒಂದಾ? Next, Karir.
Same property, 2 suits.
MD Raghunath. List along with sounds. MD Raghunath.
48.
Ramesh Koda.
But they don't ask for the declaration of their right. The dispute is only schedule B property, which is 10 feet by 40 feet. Both are neighbors. Therefore, decrease the suit. Post decree, there was a direction by the transport to pay deficit code. The road says deficit code. They enter into my property, they demolish my fence and they put up construction and encroach upon this 10 feet by 40 feet. I'm also filing an application, not permits me, for restoration of that possession bank.
Right, we'll consider. Admit call for records.
My lord, submission.
Application is not permits me.
Submission. The fact, Your Honor, the vendors of the appellant and
Correct.
respondent.
Then we decide the appeal now.
There is an order of injunction granted. Right from the inception, I have got an order of injunction.
Right, now you are in possession.
I'm in possession. Let them not in. Just 2 years back, I have given a complaint. He had given a threat just before the police officer.
Right.
Mora.
Yes.
Another subject.
Call for
submission.
record. Admit call for
Regarding
record.
jurisdiction.
In the meanwhile, the parties are directed to maintain status quo
One
of
submission.
the.
Regarding jurisdiction. I valued the suit at the rate of 7,50,000 at the time of filing the suit. Thereafter, the court has ordered me to value the suit in accordance with the sale deed. I valued the suit. The suit valuation comes at 26,50,000, and I paid the court fees. Thereafter, decree was drawn up.
So it is to go before the division bench.
Yes.
You know.
Valuation is not given to me.
Allah, Allah, decree.
Decree let's go to the. What is the value mentioned in the decree?
Not decree, they have paid twice the DC of Minot. 15,340 on 23 to 23 to 14,200. In all, total court fee is paid as 78,000.
Oh, correct, but he says that this
Valuation of the suit.
There's a
It
separate
is mentioned in
valuation.
the judgment.
But the note is Raghu.
Para 36 of the judgment. Para 36 of the judgment.
If the value is more than 15 lakhs, then it has to go before the division bench.
Lord, you cannot see the valuation slip coming to bank court at page 49.
No.
Page?
49. Because the first valuation is given by them. They value at 7,50,000.
He says that the court has asked him to reevaluate.
Court has asked him to reevaluate, but he has not published the
I have paid it on decrees, but I'm submitting before the court. Kindly see para 36 of the judgment.
So if you are valued at 26 lakhs,
yes.
What is the court fee that you are supposed to pay?
I have paid it.
Illi. DCF 15,000 ಒಂದ್ಸತಿ 14,000 ಒಂದ್ಸತಿ 26 ಲಕ್ಷಕ್ಕೆ ಎಷ್ಟಾಗುತ್ತೆ ಕೋರ್ಟ್ ಫೀ? ಕೋರ್ಟ್ ಫೀ 26 ಲಕ್ಷಕ್ಕೆ ಎಷ್ಟು? Court fee.
I have paid the values. Court, the trial court. Court fee half on.
Suit is for declaration, possession, bari declaration.
Declaration and injunction.
So it is 1,09,625 plus 4.5%, 4% exceeding 20 lakhs. Is it 27 lakhs or 26 lakhs?
26 lakhs 33,000.
24,000.
33,000.
1,33,625. Yes, he has paid.
Yes, paid, not subsequently.
Correct. So therefore, you have to, this will have to go before the division bench. Therefore, it appears from the decree that the suit was valued at a sum of rupees 26 lakhs.
33,000.
26 lakhs.
33,200.
33,200. And therefore, the appeal has to be listed before the division bench of this court. Hence, office is directed to list this appeal before the division bench. Counsel for the appellant is directed to furnish a second set of the appeal memorandum with all enclosures. List on so and so. List on the non-kodakagala, division bench. Yes, next.
Serial number 49.
Harsh Parekh.
Parekh.
My suit for recovery of money was dismissed before the trial.
Recovery of money. Emergent notice regarding rule.
Serial number 50. KK Vasant.
Mr. KK Vasant.
That came to be dismissed on the ground that cannot get to the commission appointed to identify the problem.
Yeah, take out notice, issue emergent notice regarding rule.
Serial number
B.
51.
Ramesh.
B. Ramesh.
B. R. Ravi Kumar.
Referred to, both the properties claimed by the parties have been acquired by nice manner for the benefit of nice. The additional documents were not produced. Kindly refer to the additional documents produced along with the.
Only one respondent or bare either?
Only one respondent. Now, these two properties has been acquired. Kindly refer to the sketch prepared by the KDB. He do not have the sites where he are claiming a sites in respect of site survey number 19/6. It has been acquired, road has been formed. Kindly refer to the sketch, page 133.
Yes.
Mailed portion 19/6. The 18/6 is other yellow, which is marked in yellow. That is my property. Now, they want to claim this property is form part and parcel of 19/6. Kindly refer to next.
6 or 18/6?
18/6. Our 19/6.
19/6,
134, page 134, next page, land retained and fully constructed is on the northern side of the road. Yellow mark pandirudu. It is retained in 19/6. Now he wants to claim this side of this road, nice road. Before the learned Raja, these documents were not produced. However, learned Raja holds that they have failed to produce documents and dismisses my suit.
Cool. Have you served copies of this?
Yes, I have served.
Admit call for record.
I
IR
sought
26
for-
shall be considered along with the main appeal. Parties are directed to maintain status quo in respect of the suit property. It is made clear that neither the appellant nor the respondent will change the nature of the suit property and shall not alienate, encumber, transfer, or part with possession of the suit property in any manner whatsoever until disposal of this appeal.
Much obliged.
Filing of paper books is dispensed for the time being.
Dictating order, serial number 52.
Yeah, pass over it.
Second respondent.
Pass over. Huh? Very pass over.
Passed over matters. List number 1, serial number 7.
For petition, my lord, I am needful complaints office
Huh?
objection. Complaints office objection completely, Your Honor. Yes, Your Honor.
Counsel for the appellant submits that his complaint to the office objections. Office director to check and verify and list for admission if all office objections are complied. Yes.
Serial number 11. Sridhar N.
Appellant Lordship. Lordship, we valued it as per the section 50 of the Karnataka Code Act is for the jurisdiction purpose.
50 or 49?
50, Lordship.
Over the
49 in respect of the share, Lordship. 50 for the jurisdictional purpose. In a suit as to whose value, for the purpose of determining the jurisdiction of the court, specific provision is not otherwise made in this act or in any other law, value for that purpose and value for the purpose of computing the fee payable under this act shall be the same, provided that nothing withstanding anything contained in subsection 2 of section 7, the value of land specified in clause A, B or C of the said subsection shall for the purpose of determining the jurisdiction of the courts be the market value of such land.
This suits not otherwise provided for.
No, Lordship, there's a second clause, Lordship.
No,
In a
in
suit
res-
where fee is payable under this
Madam,
act at a
please
fixed
wait.
rate.
wherever suits are not provided for in this act.
Yes, Lordship. Clause 2 says where it is fixed also market value are to be considered.
There are a list of suits.
Yes, Lordship.
If it is not otherwise provided for, then you have to resort to section 50.
Yes, Lordship.
What is your suit for? Partition.
Yes, Lordship.
It is provided for.
Yes, Lordship.
35(1).
Yes, Lordship. But when it comes to the value of the jurisdiction, I have to take the market value, Lordship. Whereas in the trial court valuation slip, they have mentioned more than 30 lakhs, Lordship.
Yes.
I have filed 2 sets of the appeal memo, Lordship.
Section 50 is not applicable.
Lordship, clause 2, Lordship. It's
For the university work.
Lordship, they say section 7, Lordships. Clause 2 of section 7 includes 35, Lordship.
First you read clause 1.
Yes, Lordship. It says in any law value where the fee payable under
Clause
this
1, please read clause 1.
in a suit as to whose value for the purpose of determining the jurisdiction of courts, specific provision is not otherwise made in this act or in any other law, value for that purpose and value for the purpose of computing the fee payable under this act shall be same.
Correct.
Correct, Lordship. Provided there is a provisional clause, Lordship, which says that notwithstanding anything contained in subsection 2 of section 7, the value of a land specified in clause A, B, or C of the said subsection shall, for the purpose of determining the jurisdiction of the courts, be the market value of such land.
Yes.
Lordship, as per section 7, clause A, B, it includes the partition 35, Lordship.
Yes.
We have valued it, though each share has been marked 7 lakhs, the overall property value is more than 30 lakhs, Lordship. The objection raised by the office is that the specific share is not been demarcated, which I have said that it is at para 38. 38, where I have said that my share, there are 14 appellants wherein 3 shares, that is 1/4 share.
What is the value of your share?
My value is 7 lakhs, Lordship.
So if it is 7 lakhs, your suit is only in respect of that 7 lakhs. Your suit
Lordship,
for partition
correct, Lordship.
valued at only 7 lakh. You have filed a suit
Yes,
to recover that share,
yes, Lordship.
which is valued at 7 lakhs.
Yes, Lordship. There's other appellants also, Lordship. Collectively, it amounts to 22 lakhs 50,000.
Yes. Other appellants ಅಂದ್ರೆ ಒಬ್ಬೊಬ್ರದ್ದು ಒಂದೊಂದು appeal ಅಂತ treat ಮಾಡಬೇಕಾಗುತ್ತೆ.
Lordship,
You can't say we'll mix 4 of us and get jurisdiction, confer jurisdiction. No. Every appellant has got a cause. Every appellant share is valued at 7.5 lakhs or 7 lakhs or whatever. If that is so, how is an appeal maintainable before the High Court? You have to go before the District Court.
based on the market value, I've appealed before the High Court, Lordship.
You cannot, Alva.
Lordship, I may be permitted to clause 2, Lordship, please.
Madam, you read 10 times.
In a suit where fee is payable under this act at fixed rate, the value for the purpose of determining the jurisdiction of court shall be the market value, or where it is not possible to estimate it at a money value, such amount as plaintiff shall state in the plaintiff.
You are seeing the skin and missing the soul. The reason is this: section 50 applies in respect of suits which are not otherwise provided in the Karnataka Court Fees and Suits Valuation Act. Subclause 2 applies, for example, if it's an agricultural land, then section 2, subsection 2 says provisions of section 7 is applicable even in respect of those suits. Section 35(1) and section 35(2) defines what should be the court fee payable. But for the purpose of jurisdiction,
Please, Lordship.
court fee is different.
Correct, Lordship.
Yet for the purpose of jurisdiction, valuation is different. For the purpose of court fee, valuation is different. Here, for the purpose of court fee, you are paid some money. But for the purpose of jurisdiction, it is 7 lakhs. So it has gone before the civil judge senior division. Appeal will go before the district court by virtue of section
Section 19, Lordship.
of
Amended Act
of
Karnataka Civil Court Act.
So therefore you have to go before the district court.
Lordship.
Section 15 ಇನ್ನೊಂದ್ಸತಿ ಓದಿ.
Please,
Please go through section 50. It applies when there are other suits for which there is no provision made. For example, if it's a declaration suit, if it's a declaration suit with possession, without possession, there is a slab.
Please, Lordship.
So if there's any other suit, for example, a preemption suit, ಅದಕ್ಕೆಲ್ಲಿ ಆ ಥರ adverse possession ಎಲ್ಲಿದು ಆ ಥರ what will you do?
Lordship, I may be permitted to go before the district court. Only the limitation aspect might be.
ಬರ್ಕೊಳ್ಳಿ ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ 30 lakhs ಅಂತ
Lordship, valuation slip. No, in appeal memo it is at page 29, Lordship.
page 29.
Yes, Lordship. 22 lakh.
ಬರ್ಕೊಳ್ಳಿ. This appeal is filed by the defendants. Sorry, plaintiff 1B, 1C, 1D,
A to
1E, 1F, 1G, 1H, 1I, plaintiff number 2, plaintiff number 3, 4, 5, 6, 7, 8, 9, 10. Challenging the judgment and decree passed in OS number 7/2018, which was a suit for partition and separate possession. The said suit was, the plaint filed in the said suit was rejected under Order 7, Rule 11A and D of CPC. By virtue of Section 2D of the Code of Civil Procedure, rejection of a plaint also amounts to a decree, and consequently the plaintiffs are bound to file an appeal before the appellate court. However, it is seen that the plaintiffs had valued the suit property at a sum of rupees 30 lakhs, and their share was valued at a sum of rupees 7,50,000 each, and full stop. Consequently, an appeal under Section 96 of the Code of Civil Procedure has to be filed before the district court in view of Section 19, subclass Civil Courts Act. Under Section 19, small Roman 1 of the Karnataka Civil Courts Act 1964. Hence, the appeal is dismissed as not maintainable. However, liberty is reserved to the appellants to file an appeal before the district court in accordance with law. Office is directed to return the certified copy of the impugned order to the learned counsel for the appellants. The time consumed in pursuing this appeal shall be deducted while considering the limitation applicable to an appeal before the district court.
Serial number 15, Nagaraj Shetty.
Serial number? Nagaraj Shetty.
There one, of course, before this first appellant is a company, Megacity. Megacity company ಗೆ NCLT ಆರ್ಡರ್ ಆಗಿ ಆ ಡೈರೆಕ್ಟರ್ಸ್ ನೆಲ್ಲ ತೆಗೆದಾಕಿ NCLT ನಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಆದ್ಮೇಲೆ the central government has appointed a new board of directors. Now it is represented by somebody else. I'll give the copy, let them ascertain, my lords. I have no difficulty.
Rejection of plaint ಮಾಡಿರೋದು on that ground.
Yeah, what is the order challenged?
Well, the order challenge is the rejection of plaint. Now, my lord, the suit is for specific performance of the agreement. That is 15,497 is the sale agreement, where that 14 lakhs was the total consideration.
ಅದನ್ನ ascertain ಮಾಡಿ ಹೇಳಿ ಅವ್ರಿಗೆ ಡೈರೆಕ್ಟರ್ಸ್ ಎಲ್ಲ they have no locus to file the appeal.
The agreement holder is the second plaintiff. Second plaintiff is the agreement holder.
Also, plaintiff is filed saying that the sale should be executed in favor of the first plaintiff.
The agreement holder, kindly see the agreement itself.
Or not pressed ಅಂತ first appeal ಮಾಡಿದ್ರೆ ಆಮೇಲೆ they can go on.
15.
ಅದರಲ್ಲಿ ಬಿಯಾಂಡ್ ದಿಸ್ ಏನಂದ್ರೆ ದಿ ಸೀಲ್ ಗೀಲ್ ಎಲ್ಲ ಅವರೇ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡ್ಕೊಂಡು ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಯಾಕೆಂದ್ರೆ NCLT ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿ NCLT ಕನ್ಫರ್ಮ್ ಆಗಿ
ಡಿಸೈಡ್ ಆಗ್ಬೇಕು.
ಇದು ಆಗಿದೆ ಆಗ್ಲೇ.
ಅಲ್ಲಲ್ಲ ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಹೌದು ಅಲ್ವಾ ಅನ್ನೋದನ್ನ ಡಿಸೈಡ್ ಆಗ್ಬೇಕಲ್ಲ.
That is
plain rejection. We are on the stage of plain rejection, not on the.
But appeal, suppose if there's some order passed by the NCLT or the NCLT.
Both
Then
NCLT
how can
and
you file
NCLT.
an appeal anta? If
ಅಲ್ಲ
somebody-
ಇದರಲ್ಲಿ this plain flood.
You no longer exist anta.
These board of directors do not exist as of today.
Is permitted to appoint directors to R1 company mega city
Agreement
bank.
is in favor of agreement is in favor of the second plaintiff.
You file a memo saying that you are not pursuing.
ಅಷ್ಟೇ ಆಮೇಲೆ ಬೇಕಾದ್ರೆ document number 1 there is a list of directors who have been appointed at page number 3. Anup Kumar Pujari, Sanjeevan Chambel, Elango Jaykumar.
ಅಲ್ಲ ಬಿಟ್ಬಿಡ್ತೀರಾ ಬಿಟ್ಬಿಡಿ.
ಆಯ್ತು ಇವ್ರನ್ನ ಬಿಟ್ಬಿಡ್ತೀವಿ ಮೆಗಾ ಸಿಟಿನ.
ಬಿಟ್ಬಿಡಿ ಮೆಮೋ ಹಾಕಿ.
ಆಯ್ತು ಈಗ ಮೆಮೋ ಹಾಕ್ತೀಯಾ? ಆಯ್ತು ಹಾಕ್ತೀವಿ ಮೆಮೋ.
Barkul, the learned senior counsel for the respondent, Kevita respondent number 7 has filed a memo along with certain documents. Which shows that the NCLT in terms of an order dated, I'm
sorry, I'll just find it. 14th March 2019.
14th March 2018.
19.
Declaring that the directors of the appellant number 1 company have ceased and were debarred from taking/involving in any action with regard to the affairs of the company with immediate effect. It also permitted the Union of India to appoint directors to the company. Full stop. He therefore contended that the appellant number 1 cannot file any appeal, and the directors of the appellant number 1 cannot represent it. Full stop. At this stage, the learned senior counsel for the appellants, after securing instructions, submitted that the appellant number 1 would be deleted from the array of parties before the trial court, and that this appeal shall be restricted only insofar as appellant number 2 is concerned. Full stop. He has filed a memo to that effect. Full stop. The same is taken on record. In that view of the matter, the appeal filed by the appellant number 1 and this appeal filed by the appellant number 1 is dismissed. Likewise, the suit filed by the appellant number 1 before the trial court also stands dismissed. In that view of the matter, the appellant number 1 in this appeal is struck off from the array of parties. Likewise, the appellant number 1 is ordered to be struck off from the array of parties before the trial court. Yes. ಮಾಡ್ಬೋದಾ ಈಗ? ಹೇಳಿ.
Blood, the sale agreement is 15,497. The agreement which we have produced along with a separate memo ಜೊತೆಗೆ ಹಾಕಿದ್ದೀವಿ. That agreement blood is in favor of Gangadhareshwara.
That is the plaintiff number 2.
Yes. Plaintiff number 2. This agreement, sale agreement is 14,06,500. As on the date of agreement, around 3 lakhs was paid. According to us, possession also is delivered. Then on 16/7/2006, 10 lakhs was paid below. And according to that receipt itself, that is in continuation of that agreement, the amount is received. Then on 16/10/2008, notice is issued, calling upon them to execute the agreement. On 7/11/2008, a reply is given stating